happened is that without any indication or reference to your lordship or ourselves, the defendants made another application for another letter from the Dubai courts, and basically what they said is there's been a misunderstanding. The word Amwal means different things to the Dubai court as it does to the DIFC court. Can you please urgently write a letter to the DIFC court and clarify that you're not supposed to execute against these shares? And the execution judge decided that request. You'll see at the bottom of page 3675, application dismissed. My Lord, no doubt what was being planned is if there hadn't been a decision, they would have said, oh, this is all under consideration by the Dubai execution judge. And if he decided to say something, no doubt that would have been a smoking gun that would have been produced. But in fact, it's rebounded against him. And he's not of the view that there's any need for any clarification of the original enforcement letter. And my Lord, just very simply, that ought to be the end of things, wasn't it? That's the first late item of news, but that's surely short circuits everything that we're talking about this morning. And no doubt that application was made on instructions.
Well, Your Honour, perhaps it's just I gather.
Party concerned is Mr. Rashed, and you know that's the end. But if I could just move on, I'll just move to the.
Sorry, Your Honour. Just I gathered you were reading it. I don't mean to cut across my own friend. I just wanted to make it clear at the outset that the first I've seen of this document is this morning, that it was sent by ultimately to my instructing solicitors. Sunday I've seen it as well. I gather Your Honour is reviewing it. I've been reviewing it in the last 30 minutes or so as well. I didn't think that there was any suggestion, certainly not from the perspective of these proceedings, that this was intended to be some kind of smoking gun. As I say, I didn't know it was going into evidence until this morning. We have our points to make on it. The short point is it doesn't really move anything along. It's an unreasoned decision that simply says the application to issue another letter has been dismissed, without stating what the reason for that is. But no doubt during the course of this morning, you're going to hear submissions about what else the Dubai court has had to say about this issue.
Well, yes, let me just read it and then I'll come back to you. Yes.
Second point, I'm happy just to make one more preliminary issue point, and then I'm going to just make a proposal about how we should proceed. But the second point, it relates to an argument that was raised in Mr. Doherty's skeleton argument at paragraph 69.
Yes, this is the raised judicata point.
Yes, my lord, and that's a point of UAE law that Mr. Doherty made submissions on in his skeleton on Monday without any supporting evidence at all. We checked that, and on Tuesday we came to the view that that was wrong. And I wanted to correct that and respond to it. So we have filed a short witness statement exhibiting two very short cassation judgments. That's a witness statement by Mr. Muhtasab, who's a partner of my friend, an experienced UAE lawyer, and the defendants have objected to that. Now, I'll show you where the page is. It's 3662.
I've read it. I was sent it earlier this morning separately, so I've read it already.
My lord, I can either just refer to the authorities, but that witness statement was really just to explain them and to respond to a point that was made for the first time on Monday. And my lord, I don't see that there's any harm done by that. In terms of it being filed late, it took 2 days for us to file it. It did require a bit of work. Mr. Mutsab was busy on Wednesday. We did have some delay filing it on the system yesterday, but in the context where Mr. Rashed has not filed an affidavit that he was directed to file in February, I don't think there's really much argument here that there's any harm done by your lordship reading that.
Well, I haven't read the authorities. I've only had the chance to read the witness statement.
Well, I'll let Mr. Doherty.
Yes. Mr. Doherty, but Mr. Doherty, are you there?
Yes.
Two things. First, I take it that Mr. Rashed is still in hospital or still unable to participate and to purge his contempt.
Yes, Your Honour. I don't know whether it was put before you. You may have seen a medical report from the 11th of December. So that letter explains the basis on which the issue arose. So effectively, Mr. Rashed developed a respiratory infection which led to laryngoscopy on the 5th of December.
Yeah.
And it says that samples obtained during surgery for a smearing culture identifying the particular cause of the infection and leading to a diagnosis of bronchopneumonia, bronchitis, and Mr. Rashed being at high risk of contamination. And so the treatment arising from that is that Mr. Rashed's been placed into a private care room under close supervision with restricted visitation. And that's said in the letter to be the case for, it says for the next 2 weeks. So presumably that'll be the 2 weeks from the date of, well, it could either be from the date of the letter or from the date of surgery, but either that would bring us through to mid next week or the beginning of the following week.
Yes, well, if it's a form of pneumonic bronchitis, which is what I understand it to be, it ought to be capable of being cleared up by antibiotics, but let's wait and see. But the effect of that is that as matters currently stand, your client is in contempt. He says he wants to purge it, but is not in a position to do so.
Yes.
The end result of that must be that any question that relates to his contempt must be stood over. And that raises then the issue of what you're entitled to argue today. Now, let me just tell you what my preliminary view about that is, and then you can address it. The preliminary view that I form, Mr. Doherty, is that the argument that you raise is not, in fact, a case that relates to prima facie jurisdiction. I'm obviously going to allow you to address me on this as to whether or not it is, but on the face of it, although quote, prima facie jurisdiction is, as expressed by the Court of Appeal, an elusive concept, and one which, in my mind, needs clarification. What it appears to be is to say that there must be a prima facie case that you fall within one of the gateways, which does not require the court to investigate in full the facts to ascertain whether that is truly the case or not. That's what I understand the position to be. Now, if that's right, then looking at the statutes with which I'm sure you're familiar, one looks first at JAL 5, and in particular then at A1E, and you look for a law that creates jurisdiction. And on the face of it, that's exactly what you have in Article 24 of the Courts Law, which creates a wholly untrammeled jurisdiction in relation to enforcement of onshore Dubai court orders. If you then go back to the JAL and look first at 5D, what that does is to put the power of execution into the hands of an execution judge. If you then go on to look at the terms of Article 7, which deals with the execution judge and execution generally, that tells you that the execution judge has jurisdiction of the kind, no doubt, that is referred to in the court's law. And when one comes then to Article 7.5, what is said there is that in addition to what appears in Clause 4 of this article, quote, when executing through the courts the judgments, decisions or orders issued by Dubai courts, the following must be observed. So what there appears is not a matter that impacts on the prima facie jurisdiction of the court, but the way in which that jurisdiction should be exercised. And the provisions which follow require the Dubai courts to issue an execution letter to the Chief Justice stating the procedure to be carried out. Then that letter being submitted to the execution judge of the court, and then the judge of the court, the execution judge, applying the procedure and rules stipulated in the rules of court. So on the face of it, what it looks as though it's saying, and you can both address me on this, is that the Dubai courts issue an execution letter which does state a procedure to be carried out. But the question that arises is if its own execution procedures do not allow execution against the shares of a private company owned by the defendant, whether in fact the prima facie jurisdiction of this court is engaged or not. So that's the first question, is there prima facie jurisdiction? The second question is, regardless of the law of Dubai, onshore Dubai, the ambit of which is in dispute, where a letter of execution refers to a restriction, is that a restriction which the DIFC court is bound to take into account? Now, it seems to me if one is executing a letter of execution, and that in clear terms says execution is to be against X, Y, or Z, but not A, B, or C, then although the matter may not go to the prima facie jurisdiction of the court, it's plainly a matter that the court would want to take into account for reasons of comity and the like. But the question arises as to whether or not one is bound by that, which may depend on exactly what the letter says. And as I understand it, we still have an argument about what the letter actually says. So those are the areas that I think have to be addressed. And it seems to me that at this stage, there is no room for me even thinking of restricting you as to how those matters fall to be addressed within the context of your client's continuing contempt. So I hope that assists you in one sense in giving you room for argument, but it does focus on the areas of argument that need to be addressed, which might in the end result in me saying, well, I don't think that this is a question which this court should be considering whilst your client is in contempt. Do you follow?
Yes, Your Honour, and I suppose if it helps, what I proposed to say this morning effectively goes to those two questions anyway, which really seem to be the questions before the court. One, do we have prima facie jurisdiction? And I'll discuss what that means. In effect, the way we see the question of prima facie jurisdiction following the decision Sandra Holding is fundamentally it is a question of whether the DIFC court, as a statutory jurisdiction and a limited jurisdiction, which needs to derive its jurisdiction, therefore, from the terms of the judicial authority law, does it have the jurisdiction or power to do the very thing it is being asked to do? And that's what's meant by prima facie jurisdiction. And I'll come on to Sandra Holdings, but that's distinct, for example, from a case where one might say that the DIFC court could have jurisdiction over a matter, say, if it comes under the 5A1 gateways of being something that has a nexus with the DIFC. There can be secondary questions that then arise from that, including, and these were the specific examples given by the Chief Justice, whether the parties have opted out of the DIFC court's jurisdiction. But other examples would be if you have arguments about forum non-conveniens, if you assert the existence of an arbitration clause, and so on. And so we say those are questions.
Well, that doesn't go wide. That doesn't go wide enough, does it? I mean, with great respect to the Chief Justice and the terms of the decision. I mean, what about a fact issue that arises in relation to a particular gateway? I mean, it's all very well talking about prima facie jurisdiction and then things that result in not exercising the jurisdiction because there's an agreement to go elsewhere or whatever. But if one simply thinks in terms of 5A1, supposing there's an argument whether there has been part performance of a contract within the DIFC. Now, the assertion made by a claimant is that there is jurisdiction, and he may have an argument that there is prima facie jurisdiction, therefore. Is the court going to say no prima facie jurisdiction after a full investigation of the facts as to whether or not there has been some form of performance? You know, these are the questions that are thrown up by the Court of Appeal decision, which really doesn't appear to me, on the face of it at least, to grapple with it.
Well, could I say something which I hope is constructive in terms of how we managed the hearing, having heard what your lordship said and what Mr. Dawley said? I don't really disagree with any of that at all. And what I was going to propose is that we've just heard that there is no dispute that contempt has not been purged. There may be justification for that. And what I was going to propose is that whatever happened, your Lordship has given permission for submissions to be made on the issue of prima facie jurisdiction, whether the contempt still exists, whether it's been purged, whether there's good reasons. So rather than arguing about all that at the beginning, I was going to propose that we just let Mr. Doherty say everything that he wants to say about the issue of prima facie jurisdiction. I will then respond to it. My Lord, if you're in a position to give an indication on that after those submissions, we might know significantly what needs to be done at the end of the hearing. There may be not much else to say, or if your Lordship is against me, there may be only some very narrow points that need to be raised about the freezing order. So I was going to propose that we let Mr. Doherty loose on that issue and let him address you on exactly what he thinks it means and how it's to be interpreted, and I'll respond to that, and your Lordship can perhaps be in a position to tell us whether you can give an indication on that issue, and then we can decide, is there anything left to say, and does Mr. Doherty have the right to say it? It may or may not be needed, depending on how those submissions work out. That was my proposal.
Yes, well, that's pretty much what I have just said.
Yeah.
The only nuance on that is this, that even if there is no question of prima facie jurisdiction, the issue that's raised about the letter of execution and whether or not effectively instructions being given by the onshore Dubai court to the DIFC court as to execution, whether that is in fact such an important point that in any event this court would be inclined to listen to it, regardless as to whether or not it is technically prima facie jurisdiction. You know, it goes to the question.
I totally understand, but rather than have an argument first about whether we have the right to make those submissions, perhaps he can say whether he can make submissions on that point, tell you that he thinks it's a question of prima facie jurisdiction. I'm going to say that it isn't. Then, my Lordship, there's probably an argument to be had later, perhaps, but we don't need to repeat the submissions that were made about the facts and the letter and so on, what they mean. So I was just trying to shortcut the wrangling at the beginning, and perhaps get that issue of prima facie jurisdiction out of the way before we have to argue about the consequences of contempt and so on and so forth. It was just simply a way of getting on with it, I think.
Yeah, well, I think we're all at one about that. So, Mr. Doherty, the floor is yours. You know the areas I'm most interested in. So
yes,
please carry on.
Thank you, Your Honour. I'm very grateful. If I can perhaps start with, I think, the preliminary issues. Just I didn't quite get to some of the points that Mr. Holloway raised earlier concerning the new evidence. As he was saying at the outset, about an hour, I think, after the registry closed yesterday evening, we received this further witness statement, which Your Honour has looked at, which gives evidence on issues of Dubai law in relation to what it says is relevant. We take issue with the relevance of what's being referred to anyway. Without getting into that, it's said to be relevant to the Dubai Court of Appeal's decision in the execution proceedings, which I'm going to take Your Honour to in due course. The short point that arises from that is that the claimant has known now for months that the defendant has placed reliance on the enforcement judgment in its set-aside application. And that was made perfectly clear at paragraph 56 of the first defendant's first statement in support of the set-aside. And for your reference, it's page 1648, but it says that the 31st January letter was never intended to affect the attachment of my shares in HMR, as my shares in HMR have gone through the litigation procedures and ended with the final ruling refusing to sell. So they've known from the outset that this hearing was going to be about the effect of the Court of Appeal's decision on the execution. The parties have long since agreed the procedure for submitting witness evidence on those applications, which ran over the course of several months. The claimants filed several witness statements in that time. And we say there can't be any reasonable justification why, after the registry closes the day before this hearing, we have another witness statement being filed. One, without any application for permission to rely on that evidence. Two, without intimating to the court or the defendants that this evidence would be coming. It's been filed without an application for relief from sanction. And although it says it is in response to a point in the skeleton argument, it isn't. It's a point that's been there since the set-aside application is made. But there's also no real explanation as to why the claimant has sat on this for 3 full working days, only to provide it the night before the hearing. And it screams very much, Your Honour, of one of those cases of seeking forgiveness, not permission. We say that the claimant knows that it actually sought permission earlier in the week. In all likelihood, it would have been refused because it would have led to orders for responsive evidence and so on. And it can't be right for the claimant to then benefit from adopting that approach of asking forgiveness, not permission, by being granted the permission to rely on that evidence that the defendants haven't had the proper opportunity to consider, and certainly haven't had any opportunity to go and look into, to research the judgments that have been cited, to provide a reply, and so on. So the primary point, Your Honour, really is that we're asking you to refuse the claimant's permission to refer to that evidence and not for it to be considered at all. If it is important evidence, it would have been filed properly and ordinarily in accordance with the timetable. If Your Honour is of the view to the contrary, that you may wish to take it into account, the defendant's position is that that places it in some difficulty in not being given a proper right or opportunity to respond. And it seems as though there are a number of options that might be open to the court. The obvious one would be the question of whether or not the hearing needs to be vacated so that that evidence can be provided and considered. But certainly some opportunity being provided to the defendants to provide that response if you are going to take it into consideration. And it may well be that that ties in with the point I think Your Honour was pressing at earlier, which was your question of whether Mr. Rashed's position is he still wishes to purchase contempt and the period of recovery. And it may well end up being the case that there's a way to case manage through that, i.e. you can hear the party submissions on the question of prima facie jurisdiction. As we say, the points I'm going to come on to in my substantive submissions are what we say goes to the court's prima facie jurisdiction. But if Your Honour was of the view that there is a point in there and there's an issue of comedy which isn't prima facie jurisdiction but is something else, then the way to case manage through that may well be to provide directions for responsive evidence to be provided to that witness evidence, but also to deal with Mr. Rashed's provision of evidence to purge the contempt, which would obviously open up what Your Honour makes of the submissions you hear. I don't think it's going to change much of what I actually say, but it may well be relevant to how Your Honour views it.
Well, the question which arises in relation to the witness statement is whether or not the decisions of the execution judge are final and binding on the merits to constitute res judicata or issue estoppel, or whether it's merely a procedural decision. You know, that's the fundamental point that arises there. So insofar as you rely on Dubai court decisions, that's significant. Insofar as you rely simply on the letter and what the letter says and what the effect of Article 7 of the JAL is in relation to that letter, the point doesn't matter. You know, it's a separate point, isn't it? Now,
Yeah, sure.
we can therefore proceed in relation to arguments about the effect of the letter and the execution letter and prima facie jurisdiction and Article 7 and Article 24 of the court law, without worrying too much about whether or not the decisions that have actually been taken are procedural decisions or substantive decisions. And I'm bound to say that if and insofar as you want to rely upon the nature of the court orders in onshore Dubai, it is obviously important whether they are or are not procedural or substantive. And that point is a point which you raised in your skeleton and which I think the claimant was entitled to seek to answer, so that I would be admitting the evidence, late as it is, in response to your skeleton, to deal with that point. If in the circumstances you say you need to take advice on that point, then there would be for a basis for adjournment, so you could do that, but only in relation to the limited point, whilst other matters could be debated which don't turn upon it. Do you follow?
Yeah, Sean, that's precisely the point we make. We do need the right to respond to that because, for reasons you'll see, we rely on the nature of the Dubai judgment. It's relevant to this question of this court's well, the two questions: one, the court's prima facie jurisdiction, but the other question that Your Honour is interested in, which is having regard to its jurisdiction, whether, as a pure matter of enforcement, the DIFC can just go ahead and follow its own execution procedures, or whether or not those have to be followed by reference to what the Dubai court has said. And so to that extent, it is relevant.
Well, it can be seen in two different ways, can't it, Mr. Doherty? If the court's jurisdiction, this court's jurisdiction, is trammelled by the terms of the letter of request, then the argument simply turns on what the request means, and it doesn't really matter what the nature of the decision made in the onshore Dubai court is. If, however, there is res judicata effect of that, because it is substantive, as you appear to be saying in your skeleton, then the position is that it is not open to the claimant to argue in this court that it can enforce against the shares. And that would be a killer point, regardless of the terms of the letter of request. Now, as I say, I think we can deal with the letter of request for execution issue today, but if you say that you're not in a position to deal with the res judicata point because there's late evidence, well, that's partly your fault for not producing the evidence at an earlier stage, but the court would want the point to be fully argued on the basis of proper evidence. So I doubt at the end of the day that that is a point that I'm going to be able to decide today, but it may or may not matter.
Well, can I reply on that very quickly?
Yes.
It simply couldn't be acceptable from a learned friend to say that he needs to adjourn the hearing to take instructions on that point. He put that point in his skeleton argument, but is he should have taken instructions before filing that skeleton argument. Not now, we're perfectly entitled to answer it. And secondly, I would be relying on those cassation authorities with or without Mr. Muhtaseb's statement. The statement simply gives them context and was trying to assist the court, but if you're not minded to admit it, there's no question of an adjournment. I'm going to make submissions on that point about the res judicata status of the execution judgment. We must resolve that. We must resolve it today. So, Lord, I think there can be no more messing around and adjourning and things like that. That we have enough material before the court, which the court can read to decide that issue. Learned Friends put his case in his skeleton we put our authorities in, you don't need to adjourn this.
Well, there's always an issue when one's dealing with onshore Dubai law in the DIFC court. If you have a judge in the DIFC court who's familiar with onshore law because he is an Emirati, that's one thing. But it's well recognized that matters of onshore Dubai law can be dealt with in two different ways before the international judges, either by submission or by evidence. And I usually prefer to have some evidence from an Emirati lawyer because the concepts are not necessarily the same when it comes to interpreting statutes or whatever. At all events, as I say, I'm going to admit the evidence. And the only question which arises at the end of the day is whether there has to be an opportunity for a reply to that of some kind from Mr. Doherty, who, as you rightly said, has raised the point and should therefore be.
He's the one who has to prove it, my lord.
Your Honour, with respect, it was never understood.
I was going to say, we've no real objection to them replying on the point. If there's a short, if you're reserving judgment, for example, we've no objection to them putting in a response on that point. But there can't be an adjournment of these hearings on this basis.
Well, let's. I say I'm admitting the evidence, so the question is only where we go from here. Let me hear everything that Mr. Doherty has to say. We'll see where we get to at the end of the day on it.
Yes, Your Honour, thank you. I suspect that the most helpful way to go through this is probably for me to just take you through the points that I want to make about the Dubai judgment, when it should be clear in your mind how we frame that and we say it fits in to the context of this case. I think the really simple point is that prior to the submission of the witness statement, it never at any point seems to have been suggested by the claimants that this wasn't a final and binding judgment of the Dubai Court of Appeal. That was certainly how it was framed on the ex parte applications, and the idea that it doesn't have force of res judicata has only just been raised, despite the fact that we've relied on that from the outset, which is why we say if that's going to become an important point in proceedings, we need to have the right to provide evidence on it. That's that. The way I'll work through my substantive submissions, Your Honour, is to go in this sequence, which is first to take Your Honour to Article 7 of the Judicial Authority Law, which is obviously going to form the basis of any discussion that we have about the court's prima facie jurisdiction. Second, I'm going to take Your Honour to the relevant Dubai court documents. And as you'll probably gathered from our initial discussions, the reason for doing that is that it's the defendant's position that those documents fix the scope of this court's jurisdiction when it comes to recognition and enforcement. And on that basis, to properly understand this case and the question of whether or not this court has jurisdiction, one has to have a clear view of what was actually decided by the Dubai courts.
Regardless of the terms of the letter.
This includes the terms of the letter. So
Well, I understand the terms of the letter can be read in the context of the decisions of the court, but the primary question must be what the letter is saying and whether that restricts this court's jurisdiction in some way.
Yes, it's the fundamental point arises from the letter. The reason that we get into the Dubai court judgments and what they mean in a little bit of detail is based on the secondary question which arises from that, which is even if the Dubai courts in their execution letter have said you must execute within these trammels, whether it's open to the DIFC court as a matter of its own procedure to say, well, I'm just going to execute as the DIFC sees fit anyway. And really the reason for going back to the judgment is to explain why that would be the wrong way for the DIFC court to approach this question. And I'll get into the English High Court decision in Lencourt to explain that point. but that's how the two fit together. And then, Your Honour, the third, I suppose, section of my oral submissions will be to take you through the points we make about the application of the law to this case and why it is. Based on the circumstances that arise, we say the court doesn't have prima facie jurisdiction. The short point, what the defendant says we get to is this, which is the claimant's position here is that it has a final and binding judgment. It says it has every right to seek to enforce that in the DIFC, and it's obtained an execution letter, which it says allows it to do so. That's the end of it. When one scratches beneath the surface of that submission, it's our position that it doesn't quite stack up. It's now the decided authority of this court that its jurisdiction is exclusively statutory. And if you don't have a statutory gateway giving rise to jurisdiction, you cannot avail yourself of the powers of the DIFC court. In enforcement cases like this one, the DIFC court's jurisdiction is parasitic on the jurisdiction of the Dubai court. Ultimately, the whole point of the judicial authority law is to create a mechanism whereby a judgment rendered onshore can be transplanted and enforced in the DIFC. But the statutory gateways which allow you to do that are prescriptive. They set out a number of conditions that need to be satisfied in order to allow you to transplant your Dubai judgment into the DIFC. And we say there are good reasons for that, not least, of course, because the DIFC court needs to be sure what it's actually enforcing, or for that matter, what it's being asked by a claimant to enforce, is consistent with what the Dubai court actually ordered. And that's the reason you have this list of requirements about the provision of translated judgments, an execution letter stating the procedures to be carried out. In effect, it's that the point is one has to ascertain what it is the Dubai court says it wants to be done. When you look at the statutory provisions, we say what the judicial authority law is not intended to do is to give a claimant a mechanism to then try and go and exceed the scope of the judgment that it has. And it certainly isn't intended to create a set of circumstances in which the DIFC court, in taking the step to enforce an onshore court decision, should then go and issue decisions and judgments which overtly conflict with the judgment that has been rendered by the Dubai court. So the point is, and we say the proper interpretation of Article 7 is that in order for the DIFC court to have prima facie enforcement jurisdiction, the preconditions to assuming jurisdiction under Article 7 JAL have to be satisfied. And if they aren't, the court cannot have jurisdiction. And similarly, where the powers or where the provisions of JAL are prescriptive and deliberately prescriptive, the DIFC court must enforce within the scope of the jurisdiction that's being conferred upon it by Article 7. And if it doesn't, it exceeds its jurisdiction and therefore acts without jurisdiction. And to give you the headline points, which I'm going to come to in more detail, the reason that we say that the claimant's enforcement action here is misconceived is that it's premised on an execution letter dated the 31st of January of this year, addressed to the Chief Justice, which is asking the DIFC court expressly to enforce pursuant to a specific set of Dubai court proceedings. That is the outcome of case 4565 of 2018. I think that might be 6545 of 2018. And what it seeks to do is to take that letter and to go to the DIFC court to enforce against the HMR shares. The problem with that is that the proceedings that are actually cited in this execution letter are the Dubai court proceedings in which we say there's a final and binding judgment expressly precluding execution against the HMR shares. And so for all the claimants might bang its drum and say that the defendant's position in these proceedings is asking Your Honour to look behind the merits of a final, binding and conclusive Dubai court judgment, the reality is somewhat different to that, because instead we have the claimant taking an execution letter issued by the Dubai court and asking the DIFC court to make orders which not only extend beyond the scope of the judgment being referenced and that was rendered, but is in fact taking that execution letter and asking the DIFC court to do exactly the opposite of what the Dubai court has said that it can do. And so we say that action cannot fall within the jurisdiction that is conferred on the DIFC court by Article 7, which, as we say, is intended to give effect to Dubai court judgments. It's not there to entitle a party to circumvent them by going to a different forum to get an answer when it gets an answer it doesn't like from the Dubai court. And so however much the claimant's position is that the defendant can continue to ignore a final and binding judgment of the Dubai court, the irony here is that that is exactly what the claimant's attempting to do through this enforcement action. And we say that it can't pick and choose which Dubai court judgment it says it wants the DIFC to give effect to and which it shouldn't.
Well, that is going to depend upon the nature of the judgment, isn't it, upon which you rely, which is a separate judgment from the original monetary judgment. I mean, it's
viewed in one sense, yes, and I think that's why I made the points that I did at the outset about evidence. It's also, one can also view it through the context of the execution letter, because of course there's a question for the DIFC court about how you interpret documents and whether, in my submission, as you'll see, one has to interpret the execution letter by reference to the context in which it's issued and the proceedings it refers to. So if you get...
I understand that, but if one goes back simply to the execution letter, which is brief, the point on its face still turns on whether or not there has been a correct translation of AMVAL, doesn't it?
That's one of the issues. We say that actually probably Your Honour can determine the issue without going there. There are a number of points I'll have to make about the word AMWAL and which translation you should prefer. But ultimately, in the same way the court would read any other document, you can construe the words that are set out by reference to the context in which they're issued. So not only do we have the AMWAL and what the competing translations, but what we say is that there's contextual evidence that supports that interpretation, including, and I'll take you to them, the request that was actually issued to the Dubai court seeking the issuance of that letter, and so what the judge will have had in mind when it was drafted, as well as all of the subsequent bits of correspondence issued by the court. So there's the direct terms and the context.
I'm much more interested in that.
Yes.
In the correspondence between the courts, which is plainly intended to clarify the purpose and meaning of the letter of execution. Because if that supports, or in fact, if that makes your case, you don't need to go back to the issue as to whether or not the execution decisions in the onshore Dubai courts were substantive or procedural or created issue estoppel.
Yes, I will, with respect, and I take your point, Your Honour, I'm still going to do that, and the reason is...
Well, I'm just trying to direct you to where
yes,
I think the focus needs to be, particularly given the fact that there is a dispute which may not be capable of being decided today about the nature of the execution court's decisions in onshore Dubai.
yes.
It seems to me at first blush that there's force in the points you make in relation to the correspondence exchanged between the courts, which throws light on the meaning of the execution letter. And if that's right, and if you're right on that point, then the issue becomes one of the jurisdiction of this court in the light of what's said in Article 7 of the JAL.
Yes, and I suppose really just to clarify our thinking, to Your Honour, is that is the guise through which we argue this case, which is to say it's an Article 7.4 and an Article 7.5 question. The reason that we get into the Dubai court judgment is to answer what one might perceive as being the follow-up question to that, which is, well, okay, if you're right about the execution letter, and so the prima facie jurisdiction of the court wasn't there, is there an ancillary question about whether there is still a hypothetical world in which the DIFC court, through its own enforcement mechanism, can act in a way that runs contrary to what the Dubai courts have done? And really, it's the reason for going to those judgments to explain to you why it can't, and to explain what the proper approach that should be adopted by the enforcement court when considering those questions is. But hopefully that should be clear by the end. If it's not, I'm sure we'll have as much back and forth as needed as we have in that point. But you're precisely right. It's the place that you get to in this case is asking, what is it that the Dubai court, in its execution letter, is saying that the DIFC should do? And our position on that is that the Dubai court has been crystal clear that the HMR shares cannot be enforced against. We say that the DIFC cannot enforce beyond the bounds of what's in the execution letter. And so the DIFC court can't execute over the HMR shares, meaning that the entire basis upon which it's argued that this court has jurisdiction to recognise and enforce falls away, meaning that you lose any jurisdictional hook under Article 7, and there can be no prima facie jurisdiction. And the effect of Sandra Holdings is that absent that prima facie jurisdiction, the court cannot make ancillary orders. That would be the freezing order and the charging order. So that's a way of saying that if prima facie jurisdiction falls, all of the orders fall.
Well, that might not be the case for the worldwide freezing order, but we can come to that.
Yes, but no doubt we will. As I say, I'm going to start.
What I'd like you to do is to take me to the correspondence to which you make reference in your skeleton in relation to the terms of execution that are being requested.
Yes, Your Honour. In order to kind of set the scene, what I'd hope to do is to just run briefly, if I can, through the judicial authority law and the framework we're approaching these questions, just to get that out of the way. So if I can ask Your Honour, first of all, to turn up page 759. You should hopefully find at the bottom of the page Article 7.4.
Yes.
Of course, we see there where the subject matter of execution is issued in the DIFC, judgment decisions and orders rendered by the Dubai courts shall be executed by the execution judge subject to the following conditions: judgment decision orders final and executory, the judgment decision or orders translated into English. You have the executory formula. Yeah. And then at the bottom of, I suppose, before we come on to Article 7.5, the first point to highlight there, which we'll come back to later, but this is relevant to the point Your Honour's just raised about the worldwide freezing order, but it's the expression where the subject matter of execution is situated in the DIFC. So one of the preconditions for executing in the DIFC is the existence of some asset there, which the claimant's trying to get at. And as I say, that's relevant if you end up being with me on the points that we make about the HMR shares, because if the HMR shares are outside the scope of what can be enforced, then there is no relevant subject matter of execution in the DIFC, and so you lose your jurisdictional hook. And that means that the court cannot make, amongst other things, a worldwide freezing order, because you need to have the prima facie jurisdiction to do that in the first place. And that's what we say the effect of Sandra Holdings is.
But if it's unknown whether or not there is an asset within the jurisdiction, does that mean the court is powerless?
In our submission, the effect of Sandra Holding is that yes, it is. It would be for a party going to seek to invoke the DIFC court's powers to explain to the court why its jurisdiction is engaged. And I'll come on to Sandra, but the point there really is that it's not enough to simply go to the court and assert that there may be jurisdiction. As I understand it, in fact, one of the arguments before the Court of Appeal in oral submissions in Sandra Holdings, which I ran through with Your Honour at the last hearing, had suggested the applicant's position there was, we haven't ruled out that there is jurisdiction because there's other claim or assets within jurisdiction. It's just that that wasn't the case that was at that time formally advanced. The point is, in the context of these proceedings, we can't just assume that the claimant is going to go away and put forward an assertion of here is, or there may well be some other assets that we're trying to get at. They have to actually turn up and explain to the court why those assets are there and why the court has prima facie jurisdiction. And if they haven't cleared the hurdle, which is what the judgment in Sandra Holding requires, the court cannot find that it has the jurisdiction to make the order at all.
Would it be good enough to say in your affidavit seeking a worldwide injunction, we have reason to believe that there may be assets within the jurisdiction? After all, they've got a judgment already. The major difference here from many other cases is that your client has already been found liable in a final and binding judgment after many, many years. So you've got the usual position of a judgment creditor trying to find assets of a judgment debtor. And in the context of a worldwide freezing order, you would ordinarily only have to show that there was reason to suspect there was something within the jurisdiction in order for the court to be willing to give you a freezing injunction. It may or may not be effective. There's a cause of action here based on the judgment. No question about that, is there?
Well, there's no substantive, if we take the HMR shares out of it, there's no substantive basis for triggering the court's jurisdiction. I mean, the way one could view it is, let's say I was desperate to get a dispute within the context of the DIFC. It wouldn't be enough for me to go to the court and make a bare and completely unevidenced assertion that there were facts and matters arising within the jurisdiction of the DIFC without actually explaining what those facts and matters are, or what the asserted contract in the DIFC is, or whatever bare level you need to get to in order to get through that gateway. And you certainly then couldn't, for example, use that jurisdictional hook, then add in a raft of other parties under a necessary and proper jurisdiction, just because you've got through the Article 5 gateway by way of bare assertion. The court wouldn't view it in that way. The court would expect you to be able to turn up to mount a response to a jurisdiction challenge, which shows that there is a substantiated basis for the court having jurisdiction through that gateway. And the same thing would apply, we say, under Article 7. So you would still have to turn up to court with a substantiated case on why you say there are assets. And that's not the way the case is premised here. It's just about the HMR shares.
Well, we'll come back to that if necessary to look at what the affidavit in support of the freezing order said. But forgive me if I've forgotten the relevant law on this, but if you have a cause of action and you apply for a worldwide freezing order, you don't need to show that there is in fact an asset within this jurisdiction, do you? If you have a cause of action.
Yes, but
By which I mean a cause of action in respect of which this court has jurisdiction.
yes, and I think that we say that the point falls just before that, because in order for the jurisdiction to crystallize in the first place, Article 7.4 says
All right.
the court needs to be satisfied with subject matter. So that's the point, really, is you need to clear that hurdle first.
Okay. All right.
Yeah.
What is Article 24 doing then of the court law if that's not giving you jurisdiction?
Yes, Your Honour. Well, that's a point I wish to address with you during the course of these submissions anyway, because one of the points being made by the claimant is, well, forget Article 7.4 for a moment, because there are a number of other routes we can get in through 5A1E on the basis of a provision of DIFC law. I think there's a suggestion that once you do that, then you just remain in the court's jurisdiction under Article 7.1. That doesn't work because Article 24 doesn't create freestanding prima facie jurisdiction. The terms in which Article 24 is drafted is, it says, pursuant to Article 7.4 of the Judicial Authority Law, the court of first instance has jurisdiction to ratify any judgment. So bear with me, I don't have the bundle page reference. My other friend might have it for the court law, if that makes it easier.
I've got it in front of me, in fact, in hard copy of it.
So the point is, you can't use.
Does it now say pursuant to Article 7.4 or simply pursuant to Article 7? As a matter of interest, the copy I've got, which is, I don't know when this one was printed off.
I've got the copy I'm looking at in front of me is, and I don't know if it's the same as the one on the bundle, but it's the consolidated version from March 22, which is on the DIFC Court's website, which says pursuant to Article 7.4. I think the case, as my friend points out, is the effective DMB is that the way one reads that now is that it means pursuant to Articles 7.4 to 7.6.
Yes, I remember.
So the short point really is that it doesn't create an extra, I suppose, gateway that you can go through in order to bring yourself within Article 5A1E, because Article 24 itself is expressly premised on the court having jurisdiction under the Judicial Authority Law. So those arguments don't actually take you any further. The core point is that in order to get in, the gateway you have to go through in the context of this case is Articles 7.4 and 7.5. And if it's a foreign judgment or arbitral award, it's 7.6.
Yep.
And to say in Article 7.5, Your Honour, going back to page 759 of the bundle,
yes,
which says, when executing judgments, decisions, or orders issued by the Dubai courts, the following must be observed. And that's where we have the Dubai court shall issue an execution letter stating the procedure to carry out. We have further reference to how the court has to get hold of legal translations of the judgment and the execution letter. And the provision about the execution judge shall apply the execution procedure and rules stipulated in the court's rules, and the judge should not reconsider the merits of the judgment, decision, or order.
yes. So the only limiting provision is A, or relevant limiting provision for today's purposes.
It's the main limiting provision for today's purposes. I think that the sort of ancillary point to that, of course, is that one has to also consider the terms of the judgment, because the point of actually getting a translated judgment in the first place is precisely this scoping idea. The DIFC court needs to be satisfied when it's enforcing a judgment that what it's doing is actually consistent with what's gone on below.
What do you say is meant by stating the procedure to be carried out? It's a somewhat odd phraseology, isn't it?
I suppose it's not necessarily unusual in what we see in some provisions of law which have got origins in Arabic provisions of law and have been translated into English, and we work our way through them. The core point is that it has to be given some meaning. So we say that they are expressed as being mandatory requirements, and if they are mandatory requirements, they have to be observed in order to execute through the DIFC court. In other words, the DIFC court's jurisdiction to enforce the Dubai court judgment isn't automatic. So it's not enough to go directly from the courtroom in Dubai and say, I have an onshore judgment and I'm entitled to ask the DIFC court to enforce this in precisely the same way as I had just had a judgment handed down by the DIFC court. And before you can avail yourself of that process and of the DIFC court's procedures, you have to have first satisfied those requirements in Article 7.5. So for jurisdiction to crystallize, we need to, first of all, as I've said, have the DIFC court acknowledge the existence of relevant subject matter for execution within the DIFC. The DIFC court needs to be satisfied that it has obtained formal documents from the Dubai court, so that's the translated judgments. And of course, central to this case, it's the execution letter from the Chief Justice stating the procedure to be carried out. And the language, whilst it might not be completely clear in what it's saying, is still important, because getting the execution letter isn't simply a formality. The words which states the procedure to be carried out by the DIFC court must carry some meaning. And we say that the DIFC court's role, and the reason these formalities and provisions in the law exist, is that the DIFC court has to execute in accordance with the underlying judgment rendered onshore, and so should only execute within the scope of that judgment. In other words, these aren't meaningless provisions. The real point is that the steps taken by the DIFC court to enforce should be consistent with what's been decided by the Dubai court. And the judicial authority law isn't supposed to give the DIFC court powers to go beyond the remit of the underlying orders which are being enforced. Or, as I said at the outset, they're certainly not intended to allow parties to circumvent the judgments, decisions, or orders rendered by the Dubai court. It's a process of transplanting into the DIFC in as smooth a way possible the judgment that has been rendered onshore. And it's intrinsic to that, we say, that the scope of the DIFC court's jurisdiction under Article 7 of the Judicial Authority Law is fixed by those prerequisites to enforcement. In other words, if the Dubai court...
What it really comes to is that the words stating the procedure to be carried out, they can't possibly refer to the mechanism, the procedure, in the sense that we think of the procedures of a court. In fact, of course, the paragraph C refers to applying the execution procedure and rules as per the rules of the DIFC court. So stating the procedure to be carried out can't be a reference to the way in which the DIFC court sets about enforcement, for example, appointment of a receiver or whatever it might be. That's not the issue. It's got to mean, and I think this is what you're submitting, but tell me if I'm wrong, is that what it is actually saying that is if the foreign court says you are to execute against whatever, but not against something else, then that has to be observed. Let's take an example. Supposing the Dubai court made an order for specific performance rather than damages, what it's saying is, well, that's the order that you have to enforce. You must enforce it in its terms. So what it really means is an execution letter to the Chief Justice of the courts stating what it is that is to be enforced.
Yes.
Is that a fair way of reading it?
Yes, that's precisely the way we put it. So, as you pointed out, Article 753 makes clear that what you're doing as the DIFC judge is taking the execution decision, and then you've got your own provisions in the RDC which says how you go about execution. So it's not about the implementation of procedural rules. What we say Article 75A is, and in fact B as well, because of course we're talking about getting copies of translated judgments. But the thrust of all of this is that it's a scoping provision. It's trying to say this is what the legislature has decided is going to be the process for taking the onshore judgment and bringing it into the DIFC. And what that means is that they have to be mutually consistent with one another. So the procedures to carry out refers to the DIFC court doing what the Dubai court is asking it to do and executing within that remit. And
now, if one stops there for the moment, Mr. Doherty, and looks simply at the judgment, the monetary judgment that has been attached to the execution letter, you don't find any restriction in that. Am I right?
But the issue here is that the execution letter, the 31st of January, which it's the first thing I'll come to once we finish looking at the law, refers to the execution proceedings. So the case reference that is given is the decision that had been rendered, what is it, 2 months, month and a half before, saying you can't sell the shares.
Well, that's what I want to be clear about. If what I think was attached to the execution letter, or sent with the execution letter, was the original monetary judgment and nothing else. Am I right?
I'm not sure I have the same clip of documents that have bundled together what was and what wasn't sent. It was pieced together in a witness statement, but I do know that the execution letter and all of the follow-up correspondence from the court refers to the execution file case number.
Right. Well, you must take me to that because that's important. I mean, if the position is that the execution letter, along with it, was submitted the execution judgment, which limits execution to money, not shares, then that's obviously important. I need to know that.
Yes, Your Honour, I know that, and if at some point there's a break, I'll see if I can speak to my instructing solicitors. I don't know if that's evidence that's in our hand, because of course the clip of documents wasn't prepared by my client, but what we can take you to is what the letter actually says.
Yes. All right. Well, when convenient.
Yes. Just to tie off those points on Article 7 is the reason we say all of this is relevant is what we say should be the fairly obvious position, which is, first of all, unless you come through the Article 7.4 or Article 7.5 gateway and satisfy its requirements, the DIFC court can't have jurisdiction and can't assume enforcement jurisdiction. And the second point is that if the DIFC court is being asked to enforce a Dubai judgment, the point of those provisions and the reason we have 7.5A and B is that it's scoping. It fixes the scope of what the DIFC court can do. And the DIFC court, we say, cannot enforce beyond the scope of the execution letter or the judgment. And if it does go beyond that scope, it will have done so exceeding its jurisdiction and whatever powers have actually been conferred on it by Article 7 of the Judicial Authority Law. And that's why it's a prima facie jurisdiction issue. Very, very briefly, just before I come on to the letters, there was one point that I wish to flag with Your Honour, which is just to look at the consistency of these provisions when one goes the other way, but also how courts go about dealing with foreign judgments. So the first point is, if one looks at Article 7.3 of the Judicial Authority Law, the point there is that you have pretty much identical requirements that apply when you've got a DIFC judgment and you want to go enforce that in the onshore Dubai courts. And that similarly provides that one must follow the procedure specified by the DIFC court. And again, we say that that's a scoping provision. The Dubai court's task there is to enforce the judgment onshore within the remit of what the DIFC court has ordered. And I suppose the comparative law example that I give in my skeleton, and which you'll find at page 3612 of the bundle, where hopefully your Honour should pull up a page which is the beginning of chapter 4 of the Federal Civil Procedure Code. And if your Honour's having difficulty with the system loading, I'm happy to read the provision out.
I've got Article 2G2.
Yes. So the point there is that if you're looking at this as an onshore court and you're dealing with a foreign judgment, what its law says is that the judgment in order delivered by the foreign country may be ordered to be executed, and then it's this phrase, under the same conditions as prescribed in the law of that country for the execution of judgments and the orders issued in the state. And the point really is just to say that there are consistent threads across both onshore and DIFC law, which say that ultimately the question for the enforcing court is to execute what is within the scope of the underlying judgment. So here it refers to executing under the same conditions that apply in the law of the country issuing judgment. And so the question for prima facie court the court's prima facie jurisdiction is really, does the court have jurisdiction to do what it is being asked to do? And that's what we get to on Article 7.4. So those are the statutory provisions. But we say that in turn necessitates, if you're with me up to that point, if these are scoping provisions, one needs to look at the Dubai court documents to work out, well, if those are scoping provisions, what is the scope of my jurisdiction? And what are the procedures that I need to follow? So the claim that the claimant files before the execution court takes place, first of all, on the 26th of November 2016. And if I can refer your Honour briefly to page 378.
Yeah.
You find
What am I looking at?
this is a page from apologies, Your Honour, I appear to have got the wrong page number there. Bear with me, I might come back to that. I'm going to find you the page reference which shows us the enforcement proceeding numbers. So bear with me, Honour, if we can just have a brief moment. So I believe this is an extract of the page I'm looking for. I'm going to ask Your Honour, first of all, to turn to page 8, and I'll circle back to this. And in fact, I can show it to you in a different way in the substance of the enforcement decision. But if you go to page 8,
eight in the bundle.
yes,
Yep. Yes. This is
the execution letter, and this is the version, the translated version that was submitted to the DIFC court when these enforcement proceedings were commenced. So this is, which I'll come on to, of course, this is the claimant's translation, the one that refers to assets rather than funds. That's not the purpose for looking at this now, but of course you'll have the terms of that, and you'll have seen the arguments about it. The point that we highlight is under subject, which is the subject heading is execution number 4565 2018.
Yes, right. Okay.
And that is the case reference number for the execution proceedings. It's not the case reference for what's been referred to as the Dubai judgment, which is a different set of proceedings. So the execution letter to the Chief Justice says that it is being sent to the DIFC court in regards to subject matter of that particular case. And so this is the 31st of January.
Right. Well, now can you now take me to the execution decision 4565 2018 to 107?
Yes.
Because on the face of it, that's what ought to have been enclosed, attached to the execution letter, or
yes,
presented to the execution judge.
Yes, Your Honour. And if, in fact, I can take you briefly through the prior chronology to that decision. So first of all, if you go to page 671.
Oh, all right. Yeah.
This is the original decision. So this is the 25th of July 2022 decision saying we authorise the sale of the share of the execution debtor in the company as stated in the application for market value per the expert's report. So this is what ultimately becomes the subject of the appeal.
Where is the case number referred to?
I think this is an extract of a document, so I don't have the full document, but I'm going to show you the case number when I come on to the Court of Appeal judgment. But pausing there, if one goes to page 1996.
Yeah. (1996).
Yes, Your Honour, I did check these page references yesterday, and I don't know whether
I've got a letter from
this is the bundle, but it shouldn't be the letter. What I'm, if you go to one. Apologies. Can I just take a moment, Your Honour, to sort out the page references? I don't know whether the page numbers have shifted slightly because of document insertions or removals, but I did check these when I was going through my note yesterday to ensure that they were correct.
Well, I know there was some problem with the uploading of the material, but
Okay, apologies, Your Honour. If you can go to 1966, that is actually my reading error.
1966.
Yes.
Right. Cool.
This is after we have the execution court saying, okay, you can execute against the shares. This is the view of the execution court on what that meant. So again, we see the subject at the top of this letter, case number 4565, commercial execution. And it says on the 23rd of August 2022, the Dubai Court of First Instance, the Dubai First Instance Court issued a letter requesting an inquiry and the placement of a seizure notice on the shares and profits belonging to the execution debtor mentioned above. So the execution court's view at that time, before we have the Court of Appeal decision being rendered, is, okay, GIFC, here you go. You can place an attachment on these shares pursuant to this case.
I'm sorry, I'm not clear what this document is that you're showing me.
It's a letter. You see at the top, it's to respected Dubai financial market. I think this is a letter that actually goes to the DIFC authority. Or at least I'd understood that that's what the claimant's position on this letter was. I'm sure that they'll correct that if it's wrong, but we can see that it's addressed to the respected Dubai financial market. And this is from the 8th of September 2022. So it's after we have the initial decision, which says, in which the execution court says you can bring about a sale of the shares. And the stated position of the execution court at this time, so this is prior to the appeal, is that one can place a seizure notice on the shares and profits belonging to the execution debtor. So that's the HMR shares, and the purpose is to secure the execution amount.
Yeah.
So this letter is supposed to be consistent with the decision that is up to that point in time being rendered by the court. And that's the decision that's then overturned. And if we go to 672, Your Honour will find the head note for the translation of what I've called in my skeleton the execution judgment. So that's the Court of Appeal decision on execution. If one looks at over the page at 673, and I will get Your Honour another reference for this just to make it clear. But the first substantive paragraph on page 673 shows that the decision that's under appeal is the commercial execution decision. So that's 4565, 2018.
It begins with the case number, which is the original case number, presumably. 25720222324, or is that the Court of Appeal number?
Sorry, where is Your Honour looking? Is that in the head note?
Right at the top of 672.
Yes, I think that's the appeal number.
Must be the appeal
That's
number.
my understanding, is it's the appeal number. And in fact, it says if you look
yes, it does.
by the third of the way down the page in appeal number 257.
Yeah, and indeed, obviously it must be because it's 2022, I think. Anyway, no matter.
And in fact, you can see it again if you look at it's the middle long paragraph on 673. It also says on the merits to accept the appeal on the merits and reissue a new judgment to cancel decision issued by the execution in file number 4565 2018. So the point there really is that file number is the execution file. And then the substance of this judgment we find at page 674. So the first main paragraph on that page, beginning whereas on the merits, the appellant argued that is the substance of the argument that is being made on appeal. So what's being said is the reasoning of the decision to sell the HMR shares was contrary to the commercial companies law. It summarises what the provisions there are of Article 20 of that law, which, Your Honour, I'm going to circle back to in any event.
Yeah, just let me read this. I just want to see what's really being said. Well, I'm looking at the argument at page 674.
Yes. Yes.
Then,
so the next is the argument on Article 81, and then the substance of the reasoning is the next paragraph, so the second to last paragraph on that page.
well, I'm not understanding this at all. They're saying Article 20 of the federal decree applies, not Article 81. And under Article 20, last sentence of the first paragraph, in addition to the rights set out in Clause 1, the creditors may file a lawsuit before the competent court to sell these shares and recover the debts out of the sale proceeds, which is exactly what we would be thinking of doing in this jurisdiction.
Your Honour, the way the argument runs here is not that. So this isn't the Dubai court saying this is a matter for the DIFC court. And I'm going to come on to break down precisely what the rationale of this judgment is. But what it's saying is that if you're looking to execute through an individual to get at their shareholding in a company, there is a rule of Dubai law which says that there's a general rule you can't do that. So that's what Article 20 says. And what Article 81 says is that there are provisions in the commercial companies law which can allow those steps to be carried out as a matter of Dubai law, but those are not engaged in this case.
Yeah.
And I can come on to the statute provisions because it appears in, I think it's Chapter 3 of the Commercial Companies Law, which is the specific provisions that deal with limited liability companies. And so what's being said is Article 81 isn't engaged here, and so we're applying the general rule that you cannot execute against the shares.
Well, this decision is drawing the distinction, isn't it, between a private company and a limited liability company. And in consequence, it says that Article 20 applies. But I'm just looking at what is being said about Article 20 in the first paragraph. And what is being said that Article 20 says, you can't recover the rights out of the share of the debtor partner in the company's capital. In other words, you can't go against the company itself and claim his share in the capital. What you can do under paragraph 2 is claim against his dividends, because that's something that's paid to him personally. And then after that, if the partner's contribution to the company consists of shares, the creditors may, in addition to the rights set out, file a lawsuit before the competent court to sell the shares and recover the debts out of the sale proceeds, which is exactly what is being sought in this jurisdiction.
Your Honour, we say that that's not what the Dubai court is saying here. So, as I set out, we've got an issue here, and I suppose to break it down, is the Dubai court here is not saying this is a DIFC company, and therefore we have no jurisdiction over a DIFC company to make any kind of a ruling in respect of these shares. That would be a quite different scenario were it to present it to Your Honour, because what Your Honour would have said then is, well, all the Dubai court is saying here is that because it's a DIFC company, we don't have the power to do this, and it's a matter for the DIFC to go do it. That's not what they say. What they do is they issue a judgment which deals with the substantive issue, which the Dubai court had no problem asserting jurisdiction over. And there's a good reason for that, which is because what we're dealing with here, I can come through the various different bits of the Dubai court proceedings where we see this, is the question before the court isn't a question of company law per se. What it's asking is, what can you do when you have an in personam judgment debt? So when you've got an individual, when can you pass through that individual's personal status to get at their shares? And it makes sense that the Dubai court has got substantive jurisdiction to make that determination. The first point is,
where does it say all that?
Because that's what these provisions of law are dealing with.
No. Look at the decision. I want to know what the court decided, and this is what the court decided. Nothing whatever about piercing the corporate veil or the personal. Nothing at all of that kind.
Beyond this is, I appreciate, and this, is not a submission that one would make if they were before an English court, but there's an important point about how one frames this issue and how one, and whether one can or cannot import the substantive law of the jurisdiction into the underlying decision. So the point here,
Mr. Doherty, this is, as I understand it, what you say should have been put before this court by the claimant in accordance with Article 752. Have I got that right? Whatever the provision is. B. This is the judgment that should have been put before the court. Is that right? The Court of Appeal judgment.
yes, Your Honour. This is what fixes the scope of the execution letter, and what this is, we say, is a substantive decision saying that you cannot go, as a matter of Dubai law, to an individual and enforce execution against their shares, and that they've made a final and binding judgment on it, and that the Dubai court had the substantive right and jurisdiction to make that determination, given the whole basis in which its jurisdiction in respect of the underlying proceedings arises. And as I say, there are some building blocks to work one's way through that. But once you go through those building blocks, we say it's quite clear how one needs to frame this issue. And the example I've given is where, if one looked at a slight inverse of the scenario here, where you had the DIFC court having determined a claim against a company and its director, and having found the company liable but the director not, because it applied its common law understanding of the differences in status between those parties, and said that one cannot pierce the corporate veil in that way. We say the equivalent is if one was then to try and take that sort of judgment in the DIFC and go to the Dubai court and to try and execute through a different prism, which argues that, well, the DIFC court didn't allow this piercing of the corporate veil, but I'm asking the Dubai court to do it because you would have approached this substantive question differently. And so I'm just asking you to approach the question by reference to the law that applies onshore, and so you can enforce against both the company and the director or the shareholder, whatever it happens to be. But the point is, just because the law that forms the basis of this Dubai Court of Appeal decision is unfamiliar to a common law practitioner, that doesn't mean that it can be disregarded or that one can superimpose the DIFC's views of substantive law on top of that to say, well, the Dubai court might not have cut through personal status in this way that the DIFC court would have, because we say that frames it incorrectly, which is the point we make that arises from the Lencourt decision, that the proper way that one has to view as the enforcement court this sort of decision is to look at what the substantive law governing the dispute says about that issue and apply that. You cannot import the common law precept of the concept of what should happen in those scenarios. And really, the 3 points to that argument, Your Honour, I'll say below in the merits claim in the Dubai court, there were various arguments about jurisdiction and the basis upon which the Dubai court had jurisdiction in the first place. And the basis upon which the Dubai court said that it did was based on the first defendant's residence within Dubai. And it says that its jurisdiction is against him as a person, not against him in his capacity as the owner of a company. What we then have in the enforcement proceedings is a question being asked of the Dubai courts, which is, if you have a debt, including a judgment debt against an individual, so it's a question of their personal status, what does the law say about your ability to cut through their personal status in order to get at the shares they own in a company? The Dubai court, in analysing that question, says, here are the provisions of law which are being relied upon, Article 20 and Article 81. And the conclusion they reach is that it's not permissible to cut across personal status in that way. They say that as a matter of law.
That just isn't what's being said in this decision. I don't know how good the translation is. It's a bizarre decision on the face of it. If you compare the first paragraph, first full paragraph on the page that we were looking at, page 674, with the third paragraph. Now, can you make sense of it for me?
Yes. Well, Your Honour, I suppose just to be clear, the first and second paragraphs are, as you often see in onshore judgments, that's just the court reciting what the legislative provisions say. So if I can show you those, it's 3431.
Don't take me to them. I want to know what you say about this document. This is the critical document. This is the judgment that I'm being asked to enforce. And what it's saying is that there's a difference between Article 20, which deals with commercial companies law, and Article 81, which deals with private companies, right? And what is undoubtedly clear from the third main paragraph is that Article 81 is not applicable and Article 20 is, right? Then you go back to what's said about Article 20 in the top paragraph, and we find that what you're not allowed to do is to recover your rights out of the share of the debtor partner in the company's capital. What you can do is claim the debtor's share in the company's profits, i.e. dividends. And then if the company is terminated, you can pay the partner's share, you can monetize the partner's share on termination. And if the partner's contribution to the company consists of shares in any event, then in addition to the rights, they may file a lawsuit to sell the shares. Now, exactly what was being sought in Dubai is somewhat unclear, because if you then look down at the third paragraph, it says Article 20 applies, and then as such, the share of the appellant therein may not be sold, which must be a reference to point 1 in the first paragraph. You can't recover rights out of the share of the debtor partner in the company's capital. In other words, you can't simply go against the company and say, because he's a 50% shareholder or 100% shareholder, I can have it. I can have all that the company has. But what you can do is claim against the dividends, his share of the profits, or you can claim, ask for a sale of the shares and recover from the proceeds of the sale of the shares. Now, when you then go back to paragraph 3, you say the appeal decision violated the perspective. It should be cancelled and new judgment issued to reject the request to sell the shares in the plural, as will be stated in the working of the judgment. Now, I don't know exactly what it was that was being sought, but on the face of what they're saying, 120 applies and you can sell the shares. You have to apply to the court for sale of the shares.
Your Honour, we don't accept that that is the correct construction of this. There are other reasons for that. One is if one looks at the scoping provisions in Article 9, I think it is, of the Commercial Companies Law, it says the types of companies that it can apply to. I think what perhaps this judgment means to say is neither Article 81 nor 20 play. It depends how one reads, rather. But the point remains the same, which is the decision is the sentence that follows immediately after that. It says, as such, the share of the appellant therein may not be sold.
Yes.
And the appeal decision violated this perspective. And it says it again now, therefore, at the bottom of the page. So
that's clear in what it's saying until we get to whereas the appeal decision violated the perspective. What it's saying is you can't simply sell the share of the defendant in the company by reference to Article 20, by which it obviously means you can't simply say, I can have the proportionate part of the company's assets. What you have to do is either terminate the company, liquidate it, and then you can pay out the partner's share, or alternatively, you can sell the shares in the company. That's expressly what 120 says and what the court says is applicable. So it may be necessary to go back and see what it was that was actually being sought, which was said to violate those provisions.
Well, Your Honour, we would say that the subsequent context makes the decision of the court abundantly clear. And the point is that having rationalised these provisions of law, what the Dubai court says is you can't sell the shares. That much is clear. It says it again at the bottom. The court ruled to accept the appeal in form and merits to revoke the appeal decision and to issue a new order rejecting the request to sell the appellant shares in HMR Investment Holding.
I understand that, but I want to know how that possibly stacks with what they've just said and whether I've got an accurate translation. I mean, it just doesn't make any sense, this at all, particularly as Article 120 appears to say exactly what a common law court would say. I mean, I'm just not persuaded I've got the right materials here. and these translations are necessarily accurate. Can we see what it was that was actually being sought from the court? Does the first instance decision help us on that?
Yes, well, Your Honour, I think it's the sale of the HMR shares is what's being sought, and the court has said no, and it's applied those provisions of law and it's said no. The takeaway point from our perspective is that the Dubai court, in reaching that outcome, was satisfied that it had substantive jurisdiction to make that decision, and the reason it had that ability to make the decision was because ultimately the question is one of how one passes through personal status. That's why I made the comparison to piercing the corporate veil. I appreciate it's the other way around, but it's a similar notion.
Where do you get that from in the judgment here, or indeed in the judgment below, where that's might have been discussed?
The basis of the argument is that the provisions of law.
I'm sorry, where do I see it in the documents, Mr. Doherty? You've got to show me the basis. This is the judgment which you're telling me is the one that ought to have been enforced.
Yes, Your Honour. It's the recitation of law says that the general rule is that you cannot take an individual and enforce against their shares. That's Article 21. And what the court then says.
That's exactly not what it says. That's why I'm having such terrible trouble, Mr. Doherty. What it's saying in the first paragraph, as that Article 20 says, is exactly what you would expect it to say in the context of the difference between an individual and the corporate personality of a company. You can't break into the company and simply take out his proportionate part of it, of its assets. What you can do is enforce against his dividends, and what you can do is get a sale of his shares and enforce against that, which is exactly orthodox common law, company law.
John, I think probably we disagree on that point, because ultimately the decision that is rendered says you cannot force the sale of the shares.
I understand that, Mr. Doherty, if that's an accurate translation. But what I need to see, I think, is what the first instance decision said, and to try and put this in context as to whether or not that really is an accurate translation, because it is fundamentally inconsistent with what they've just said in the first paragraph. You know, if it starts off by saying the share of the appellant may not be sold, which must mean within Article 120, the share in the assets of the company. And then it goes on to say that the appeal decision violated that, and a new judgment issued to reject the request to sell, as will be stated in the working of the judgment. But I haven't seen that. I want to see where this is set out as to what it is they're really saying.
Should I take you to those pages, Mo?
Which pages do you want to take me to, Mr. Holloway?
The first instance decision first, page 671.
671?
Okay.
Right, well, let's have a look at that and see if that helps.
It says share, not shares.
Yeah, I think this is the same document I took you to earlier.
And then the application.
Hold on. Let's go back. Come on. Is this all we have? Page 671.
No, there is I think that's the sum total of the decision. But there is the application, and that's at 2098. At the bottom of that page, sorry, two.
Right. Yeah, well, there we are.
Share, not shares.
There we are.
But Your Honour, I'm not sure how much that moves things on, because what it says is application for the sale of movable properties, real estate properties, stroke others.
If you go to,
And I don't think it had been asserted up to this point that what.
If we look at
It's
the
quite-
198 at the bottom there of 2099,
I'm sorry, where are you going to next?
this is the application, I believe, and how it was determined in 2099. The summary 198 at the very end, it says we authorise an accounting expert to be appointed to appraise the debtor's share in the company.
Sorry, I've got lost the page. What page did you just say? 209.
99. You see,
Sorry, Mr. Holloway, there was feedback. Page again.
2099. Looking at the very end of that,
Okay.
there's a 198.
This is farcical. Right, 2099.
If you see, upon review, this is where they executed by appointing the expert to value, and it was valuing the share.
Yes.
And you'll remember that the expert, he didn't value the shares per se, he valued the company. We went through that.
Yeah.
Party here.
What is page 2099 that I'm looking at? What is that?
That was the request and the decision. I believe it summarises the requests that were made and then comes to the conclusion.
That's the full request and the full decision.
So it's yeah, the sum total of the request for execution and the decision. You go to the top of the document.
The trouble is that I don't know what I'm looking at. If I go back to 2098, I've got a document that begins 139 in the left-hand corner, and then application for sale of movable properties, real estate properties, shares, etc.
That we submitted in the execution.
Yeah,
The second box is the judge's decision.
yeah. I believe the 139 is request number in the execution file, and then that's a sort of.
I've got you. And then it's the decision at the bottom.
Yes.
Well, it's a complete misunderstanding by the first instance judge of what he was being asked to do.
That misunderstanding has been taken advantage of, we would say.
I'm sorry, Your Honour, I really have to cut across this, because this is an entirely revisionist take by the claimant on what it is that they're asking for. The documents that you're just looking at say in the left-hand column that amongst what they're seeking to enforce against are shares. If you go to the bottom of page, I think it's 20, but I've just flicked over to another page, 2098, was it?
Yeah.
And scroll through that. I think it's the last paragraph before we get to the decision. It might be on 2099. Mine is still loading. But there's the reference at bullet point 5 to the discussions that had been had with the DIFC courts about there being approved procedures for the sale of shares.
Yeah.
And so they have no objection with the Dubai courts proceeding with the sale procedures, i.e. what we're talking about here is the sale of shares. But in case there's any mistake about what it was that the claimant was asking the Dubai court to do here, if Your Honour goes to page 55,
Page 55.
yes, which is Mr. Ramsey's affidavit.
Yes. Well,
And then the suggestion that one is taking advantage of a mistranslation issue. But what he says in paragraph 45, on 25th of July, following a request by the claimant, the Dubai courts authorised the sale of Mr. Rashed's shares in HMR via public auction. On the 20th of November, following an appeal of the decision of the Dubai courts authorising the sale of Mr. Rashed's shares in HMR, the Dubai Court of Appeal decided to overturn the first instance decision on the basis that Article 81, which allows the sale of a judgment debtor's shareholding in a limited liability company by way of execution, does not apply to HMR, seeing as it's a private company and not a limited liability company. So I don't think it can be correct to say
well, it's
this is a
completely
misunderstanding or we're talking about different things. The execution court from the outset was being asked to deal with a sale of shares. That's what they've been asked to do. That's what the provisions of law that were looked at were governing. And even if the claimant was to now come and say, well, you know, we were actually talking about a sale of the proportion of the assets of the company, not the shareholding, which is what Mr. Ramsey refers to expressly in paragraph 46 of his statement, they still find themselves in a bit of hot water, because if Your Honour was to come to the view that there are procedures in the Dubai court which say, actually, the Dubai court does have the power to sell shares in this way, that's how I read Article 22, then the place that the claimant needs to go to bring about that sale is the Dubai court, not the DIFC court, because the Dubai court has already said, we are in the place to make a decision about this issue. They haven't declined, the Court of Appeal decision wasn't, we don't have jurisdiction, so this is not a matter for us. They have looked at the substantive issues before it, and they have made a decision on it. And the decision that they made is that it was impermissible to pass through a judgment debtor to his shares in that way. And we might not like the reasoning. We might think that the reasoning could be clearer, but the decision is the Dubai court's decision. And just because a common law practitioner might not like it, or it might have decided something different, that is irrelevant. And that's not what the execution court is tasked with doing, because that's asking us to dive into the merits of the decision, which of course, under Article 7, 5, D, I think it is, we're not entitled to go behind the merits of what the Dubai court has said. And what the Dubai court judgment in the proceedings, which are referenced in the execution letter, says, in clear terms, we say, is you can't sell the shares. And we say that's made clear not only in the outcome that's reached, but also in all of the subsequent correspondence, which is where I'd hope to take Your Honour to next, to show that.
You'll have to do that, because on the face of it, what is being said is a complete nonsense. I mean, I just don't accept what you say. The supporting affidavit simply does not accurately describe the first instance decision. It's quite plain on a proper reading the first instance decision that what was being asked for was a sale of the shares, and what he ordered was a sale of the proportionate of the company's capital, with a valuation to be done by an expert. Complete nonsense. And then when it gets to the Court of Appeal, what the Court of Appeal says is, no, you can't do that. We're going to send that, we're going to overturn that, which leaves the position, as matters stand at that point, that under Article 120, an application should have been made once again to sell the shares, and the court ought to, on the basis of the Court of Appeal decision, have agreed to do that. Now, it may be that they would or they wouldn't because the shares are shares of a DIFC company. But that's what the position is, and that therefore what ought to be the subject of enforcement letter would be the original decision on a monetary judgment. I mean, this is becoming a complete nonsense on the face of it. There seems to be a complete misunderstanding as to what was applied for and what was actually ordered. Now let's look at the letters you want to look at, because we'll see if that misunderstanding is perpetuated or not.
Yeah, sure. I suppose I should just reiterate at the outset that we don't.
I understand you don't accept that, but I'm bound to say, on the face of it, it appears to be a very clear position.
Even if one were to remove, even if it was considered to be a translation issue, I mean, really, it's the translation of share singular instead of shares plural,
Yeah,
which we say, which in my respectful submission, Your Honour, we say is reading too much into that. But in any event, the point is, by the time we get to the Court of Appeal, they are talking about shares, and they have said you cannot execute against the shares. And so if we go to the letters.
Well, that's not what the Court of Appeal has said, is it quite? Its decision is actually to overturn the decision taken below on the basis of Article 120. That's what it's done. Now, whether or not there's a mistranslation in the bit that immediately precedes it, because people haven't understood when translating the difference between a share of the proportionate capital of a company and shares in a limited company, is unclear, but one suspects that's the case because translators are not familiar with the whole idea of incorporation and what that means. Whereas Article 120 reveals a very clear understanding, exactly what one would expect. But let's look at the correspondence, because I'm against you on what the decision means, and the question then is whether the letter of execution is trammelled in the way that you say that it is.
Yeah, sure. Before I do that, I just want to repeat not only that paragraph, the sort of third paragraph of page 674, but
Yeah.
it's the holding provision in 675, which says now, comma, therefore.
Yeah, let me just look at that. 675.
674. It's the bit at the very bottom of the page.
Yeah, thank you.
And the point is that it's not the Court of Appeal kicking this down back below to say go reconsider based on the proper issue. The Court of Appeal is positively saying we are issuing a new order to replace the order of the first instance court, rejecting the request to sell the appellant's shares in HMR Investment Holding Limited. It's not talking about selling the assets in HMR Investment Limited. It's talking about selling the shares. And we say that that's the point that is the binding decision of the Dubai Court of Appeal. And for reasons I'll come on to why one is framing this case, you have to frame it by reference to that decision. And the correspondence then gives us the broader context, which shows that this is what the court meant. This isn't a translation issue. This isn't courts talking at cross purposes.
Right.
And in my respectful submission, finding that the court are talking at cross purposes is trespassing on what the decision says and means anyway, and is not the remit of an execution court. The first page reference is.
I'm really sorry to interrupt, but it's simply that, my lord, you're disappearing from my picture, and there's a lot of interference. I'm not sure if it's just me. I'm sorry, Mr. Doherty, for interrupting, but I just...
That's okay.
I'm flashing on my screen, so I've just turned my camera off. But I trust you can hear me. The flashing is as long as you can hear me, that's all right. If I disappear completely, then I'll find some way of letting you know. But for the moment, I'll turn my camera off. There's obviously some interference of some kind. Yes, well, let's look at the correspondence, Mr. Doherty. I have your submissions on that, and I'm about to say I'm not with you as matters currently stand. And it may be at the end of the day, I'm going to say that this matter has to be adjourned in order that the matter be properly explored with evidence as to what are the proper translations and evidence indeed of the relevant law and what was decided. As I see it at present, the only sense that can be made of the Court of Appeal decision is that the final paragraph has a mistranslation of appellant's shares, where it should read the appellant's share in HMR Investment Holding, because that was the decision made by the first instance court that they were overturning. And the same point applies to the translation on the 1, 2, 3 in the penultimate line, anti-penultimate line of the preceding paragraph, because otherwise the sentence makes no sense. The whole decision makes no sense at all. I mean, it's madness. And unless I'm clear about that, I can't see how I can properly make a decision on this. But let's look at the correspondence and see if that in any way helps.
Yes.
I suspect that what it's going to do is confuse the issue yet further, but there it is.
Potentially, my lord, but that might just be a by effect of my own submissions. I'll try and take you through it as clearly as I can. Can I just, before I move on to that, point out that the translation that we're dealing with is from Naji Assad's legal translation, which is the claimant's translator who translates the execution judgment, the execution letter, sorry.
I dare say, Mr. Doherty, but if you can't,
it's not our translator.
If you can't see that the Court of Appeal decision on its face doesn't make sense as translated, probably nothing I can say can persuade you. But since it's your job to try and persuade me, and I need to be satisfied what the true position is, I fear we're just going to have to adjourn in order to get the thing sorted out, to find out what really was being said in that decision.
Yes, I understand Your Honour's position. The reason for flagging that was because I'm going to come on to the execution letter and the translation issue that Your Honour is aware of, and when one is looking at competing translations.
Another one there, yeah, quite.
Well, if one is looking at competing translations, one might want to consider, if you've taken a view that Naji Assad's translations are wrong, there are other translators that one might rely on, and that might assist you on this funds versus assets issue. Because if there's a failure to appreciate in your own view, or at least ambiguity over the translation of share and shares, the same might apply to fund and assets.
And at the end of the day, what I'm thinking, Mr. Doherty, is this, and I'm thinking out loud here, is that actually what's going to be needed is for us to have evidence from lawyers who are familiar with the Arabic and familiar with the system in Dubai. In other words, we've got to have people from onshore Dubai who are qualified lawyers who are able to tell us what this really means and what the decision really consists of. And maybe it'll have to be argued as to what it means because there's a problem about it.
Yes.
But as it stands, I mean, I'm just deeply troubled by it.
Yes,
anyway,
I understand. If I can perhaps, as best I can, I'm not going to be able to help you, I'm afraid, Your Honour, with those aspects of it. But what I can try and do is to give you the context, which obviously is one of the tools that the court can use to assist its understanding of documents.
Yes.
You'll recall that I took you to the document at page 1966, which was the September letter issued to the DIFC court. So this was after the execution decision, but before the execution appeal. And that was the letter which requested placement of a seizure notice on the shares and profits belonging to the execution debtor. And then chronologically, what we have is the November 2022 decision, which we've looked at. And then the next bit of correspondence in sequence is at 1963. Where Your Honour should hopefully find a letter from the 18th of November 2022 from the Dubai First Instance Commercial Court to, it says, the respected Dubai International Financial Centre. And the subject, as we've seen, has become the formula for these letters. It says case number 4565/2018. So that's the execution reference.
Yeah.
And we have the text of this letter, which says the Dubai Court of First Instance has issued a letter stating that the seizure order has been lifted and that the action taken on the basis of our previous letter can be cancelled. The court is treating the letter as if it had never been issued.
Yes.
So what we say is that that reflects the change in the court's position from freeze these shares to we're treating that letter as though it was never issued. And that's obviously tied in with what the Dubai Court of Appeal has said on that execution decision. If we then progress forward to page 2142,
Right.
and if Your Honour has that,
No, wait a second. Sorry.
yes, that's fine. Apologies, I can't see. So if you were able to let me know when you've got it, that might be.
Yeah. Okay. Well, I'm back and not flashing anymore. So right. 2142. Yes.
So this is text of the request that is being made. So this precedes the issuance of the execution letter.
This is 24th January 2023. Right.
Yes. And says the relevant point here really is, so I suppose a couple of points in the first main paragraph, which is the request before we get to the decision.
Yeah.
We see here's the explanatory memorandum seeking delegation of the DRC courts to execute the judgment issued against the funds of the defendant that are permissible to be executed within the DIFC.
Yeah.
And then the decision text below that says the DIFC courts are hereby delegated to seize the judged amount against any funds of the defendant according to the applicable procedures.
Yes.
And the 2 points there. One, if we take note, first of all, this is the legal translation service, Hadi Abu Ghazala legal translation. And their translation, which they use twice here, refers to the subject matter of execution being funds and not assets. And that's repeated, of course, at the bottom of the page when it comes to the decision. And then the second point is that the request itself is not a blanket request, it's one which has got a defined scope, regardless of whether you use the word funds or assets before it, because it's talking about whether it's funds or assets, ultimately what is permissible to be executed in the DIFC. And so we say that at the time the request is issued of the court, this is only a month and a half, 2 months after we have what we say is the final binding judgment of the Dubai courts about the execution of the shares, which says that it's not permissible. And so when the execution judge is receiving this request for execution against funds or assets which are permissible to be executed, that's obviously the context in which they would have issued their letter. And it's what the Dubai Execution Court will have had in mind when they decide what the terms of that letter should be. And just pausing again while I'm on that, if you scroll down to page 2146,
Yeah. What's that?
Apologies, 2147 it is. As I understand it, this is a translation of the same document that we've been looking at just now, but the translator here is Sauson Latifa Legal Translation and Trademark. You can see the stamp at the bottom of the page.
Yeah.
And the point to flag to you there is that, again, here we have another translator using that term funds both times
Yes.
on the decision rather than assets. So it's, when one is considering the context of this, looking at multiple translations which have used the term funds and others which the assets. And then for completion, just on that point, Your Honour, if I can take you to 1972.
Sorry, page number again.
1972.
Yeah.
Which is the alternative translation of the execution letters to the 31st letter. It's consistent with the other iteration that you looked at in that the subject matter also refers to the execution file, 4565 2018. And this iteration of the letter refers to the funds, the foregoing in 4C.
And in each of these documents you're showing me, is it the same term that's used in the Arabic?
Well, I think they're translating. Well, the execution letter is certainly translating the same term. I don't know the answer, and I don't think I can give you the answer about the other document.
One would suspect it is, because
Yes.
that's simply the terminology they would use. Well, one would suspect it's probably Amwal on every occasion, but
yes.
Okay.
And the point here, again, just to flag, is this is the third now separate translator that has also used this term funds. So the submission there is really just a question of weighting, where we've got one translator versus three, which, when you place it in the remaining context, we say is pretty helpful evidence, because the request that the execution judge receives is one which asks him to execute against whatever is permissible to be executed against. The request and the letter both refer back, we say, to the Dubai court judgment issued only 2 months ago, and has to be seen as part of the context in which the execution judge would have sat down and issued that letter saying what is to be executed against. And so when we say what is meant by this letter is execute against funds, not assets, is because it's very, very difficult to read what the Dubai court is intending to do here without having regard to the Court of Appeal decision rendered only 2 months previously, which says you can't sell the shares. That's our position, and I understand what Your Honour has to say about that. But the contextual evidence doesn't just arise, we say, before the execution letter goes out, it also postdates too. So the next document is 1981. And this is another decision rendered by the Dubai Court of Appeal on the 26th of July 2023.
Right.
And this is in relation, I suppose, if I can summarize it, to the discussions that have been ongoing with the Dubai courts about what the scope of the execution should be. So the issues that kind of have been rumbling along both in the DIFC and also in the Dubai courts. And the relevant part that I'd refer Your Honour to of this decision is on page 1983.
Well, I'm just going to read all of this to make sure I'm getting it.
This one, I have to say, Your Honour, is if you find the last judgment difficult to read, this one you might find it more difficult to read. Which is why I wasn't going to quote. Well, I was trying to limit the lengthy extracts. I was going to quote the bits which should hopefully give you the ratio of the decision.
Yeah. All right. So that's clearly on the face of it in the plural.
Yeah, so Your Honour will probably have gathered that the bit that I'm referring to is effectively the last sort of section of the substantive paragraph beginning at the top of 1983, beginning continuous attachment of the appellant's shares in HMR and the inadmissibility of a continuation of forced execution thereof by sale attachment of those shares is unacceptable since it's a consequence of the inadmissibility of sale. So this, we say, is largely a repetition of what the Court of Appeal said back in November. And then it says, whereas the execution judge decision violated this view, the court decides to repeal it and adjudicate to lift the attachment of the appellant shares in HMR holding. And then we have the summary of the court ruled at the bottom to judge again to lift attachment of the appellant's shares in HMR investment holding in order for the respondent to pay the costs, etc. So post issuance of the execution letter, what we say this document shows is it remains the Dubai court's view that you can't attach the shares and you can't execute against the shares. And we then have a letter which is issued off the back of that on the 1st of August. That's page 1992.
Just while we're getting that letter, my lord, I'm sorry to interrupt again, but I'm just gently marking the clock. We're 2.5 hours now into what was listed as a 4-hour hearing. I'm not just saying any more than perhaps we could take a view as to how much longer we're all going to be and whether I'm going to get to say something.
I rather suspect we're not going to reach a conclusion today for reasons I've already referred to.
Well, my lord, I'd be strongly resisting any proposed adjournment, and I'll address you on that when the appropriate time comes. But
well, I'm sure I understand that entirely, Mr. Holloway, given the whole history of this case. But the reality is that if I'm not in a position to make a decision, because I don't think I've got all the right material before me.
Well, my lord, the right in my submission, whatever you make of those decisions, whether it says shares or not, it doesn't matter. The decision isn't binding.
Right. Well, we can come to that in just a moment. Mr. Doherty, yes. Are you going to be done within half an hour?
I hope so, yes. I've noted the time and I take all of those points on. I know that we've been discussing a number of issues in different sequences, and I'll make my points efficiently. And I'm minded with what Your Honour has already said about your position to address certain of the issues I've raised, if I put it that way. So just to run through the remainder of the correspondence, I don't know if you've got 1992 in front of you.
I have.
So this is another letter. It follows the same format. It refers to the same subject proceedings.
Yeah.
And this one says, on the 31st of July 23, again, this is addressed to the Dubai International Financial Centre, I should say. The Dubai Court of First Instance decided to address you in respect of lifting the attachment of the defendant's shares in HMR holding limited license number. Regards. And if we go to the next page, sorry, not the next page, page 1998.
Yeah. Yes.
This time, similar format, refers to the same subject. This time it's addressed specifically to, it says the president, it'll mean the Chief Justice of the Dubai International Financial Centre Courts. This
Yes.
is on the 15th of August. So
Yeah.
just a couple of weeks after the Court of Appeal decision that we've looked at. And it says the Dubai Court of First Instance has decided on the 15th of August to address you, requesting the lifting of the freeze on the shares of the respondent in HMR Investment Holding Company, license number, etc.
Yes.
And then another one on the 18th of September, which is 2146.
So that's asking us to release the worldwide freezing order.
That's what we say the effect of this is. I'm sure that Mr. Holloway, if I ever give him the opportunity to speak, will probably say something different, but that's what we say must be the import of this correspondence, because the Dubai court, in referring to this execution file, is asking the DIC to do something, and it's clarifying its scope through this. The next one, as I say, I'll go through these quickly. We've got 2146. This is the 18th of September. Same format again. Again, this is to the Chief Justice, and this one simply refers back to the previous letter and says the Court of First Instance has decided to write you to inform us about the attachments placed, i.e., can you please provide an update? Following our last correspondence would be another way of reading this in shorthand. And then I think for completeness, it's probably only fair to refer to the new document that went in this morning. As I say, Your Honour, I haven't had the time to digest this. I'm not entirely sure. I'm not entirely sure what the document is or how it's come up, and that might be my fault. But all I want to say about that, Mr. Holloway referred to it this morning. It seems to be a request, effectively, to clarify the issue, and just says the application is dismissed. But I don't know if the basis for that dismissal is we've been clear already and we've already sent these letters, or whether there's more to it than that. I simply don't know. But I don't think it takes anything away from the letters which the Dubai court have previously been issuing to the DIFC saying lift the attachments, as well as the timing of those letters. So the fact that they came after the Court of Appeal had made decisions saying you can't sell the shares and we're lifting the attachment on the shares. So when one is asking what
they don't do is specifically to clarify the terms of the letter of request. I mean, there's no doubt that they are requesting a lifting of the freezing order. I can see that. You can't read that any other way, I don't think. But anyway, there we are.
Yes,
you can, and you should.
All right. All right. Hold it away. You'll have a chance in a moment.
The point of all of that really is to show, not only before we get the execution letter, but also in correspondence that is sent in follow-up to the execution letter, what the Dubai court is telling the DIFC is, one, you should treat our previous correspondence saying you can execute and attach the shares as though that never existed. And in fact, we're writing to the Chief Justice specifically in respect of this case, saying you can't execute over the HMR shares and lift the attachment. And that gives us insight not only into what the Dubai Court of Appeal actually decided back in November 22, but also what the scope of what the Dubai court is asking the DIFC to do in these execution procedures. So when we get the execution letter and the DIFC court is saying, do I have jurisdiction to execute? It has to go within those trammels, and it cannot exceed the scope of what it's being asked to do.
Right.
And before I'll come on to make some summary points of how one brings all of that together. But before I do that, I just want to briefly address this question that, you know, what I expect might be said is, well, it doesn't matter what the Dubai courts are saying, and it doesn't matter that the Dubai courts are telling you that you can't, or that you shouldn't enforce against these shares, because the question is one for the DIFC court, and, well, can I enforce anyway, irrespective of what the Dubai court says? And we say two things. One, no, you can't, because if you go outside the scope of what the Dubai court says, you don't have prima facie jurisdiction. But the other point is simply that that's the wrong way to frame the role of an execution court. And that's where we cite the Glencore High Court judgment. Your Honour will find that beginning at page 3583. So this is before Master Davison. This was appealed to the Court of Appeal, but the decision was upheld. And you'll have noted from my skeleton argument that we say that there are some helpful conceptual parallels one may draw between that case and this case. So here we've got an underlying claim. So the merits claim is before the Dubai court. We've got the defendant, who's Mr. Puri, who's the sole shareholder of a company called IPC. And IPC draw a number of checks for Glencore, which were assigned by Mr. Puri in his capacity as a director of IPC. And those checks are then delivered to a sister company, and it's those companies that have got an agreement. We have an arbitration. IPC becomes the judgment debtor of the Glencore sister company. That award goes unsatisfied, and what Glencore decide to do is we're going to go encash these checks, which weren't honoured, and that leads to civil and criminal proceedings in onshore Dubai against Mr. Puri in his personal capacity. And they then get judgment onshore against him. It's under Article 599 of the Commercial Transactions Law, but effectively they say you're the signatory of these checks, you're personally liable, even though the underlying dispute is between these corporate entities and was resolved in the arbitration. This is the way that the Dubai courts are entitled to treat you as the signatory of a check. And the parallels we say are the argument in Glencore being raised by Mr. Puri is that enforcement would have been contrary to the public policy of England and Wales, on the basis that this is an impermissible piercing of the corporate veil. In other words, the English courts faced with this sort of a case would never have found Mr. Puri personally liable in that way that the Dubai court had, and the English court should therefore decline to enforce on that basis. That was the argument being run. The relevant part of the judgment is relatively short. It's the paragraph 30, which is page 3589.
Yeah, I read that.
Which I'll.
It doesn't really help us, does it? Because it's a public policy issue.
It's not. It's the point that we derive from it isn't about public policy, but it's about how you frame the role of the execution court. So the relevant extract of this paragraph 30, we see the summary of the argument in the first sentence. The second sentence. English law would not have imposed personal liability in the same way that Dubai law did. And if we go to the 6th line down, I think it is, beginning the rules.
Yeah.
What the court says is that the rules that Mr. Cooper referred to are English rules relating to English company and commercial law. They're not principles of public policy. And he says the case against Mr. Puri in Dubai was resolved according to the rules which the laws of Dubai apply to Dubai companies and to individuals who write checks on Dubai accounts. As I've already observed, Mr. Puri operated in Dubai, and he knew that in writing the checks, he was subject to Dubai law. As I've said, there's nothing that would be repugnant to English public policy in giving effect to the judgment, which is based on Article 5992, i.e., the provision of UAE law.
Well,
What we draw from that is it's a framing point, because it doesn't matter if the foreign jurisdiction answers the question in a way that the English court, applying common law principles, might have. And it's therefore irrelevant if the English courts had a rule preventing piercing of the corporate veil, because ultimately what the enforcement court has to do is say, well, what does the governing law say about this issue? And we're just enforcing what the governing law says. And the second point that I think you can derive from that is that the enforcing court doesn't simply superimpose its own substantive laws and standards to questions like that. What the judge says is, I have to apply or determine this dispute, and I quote, according to the rules which the laws of Dubai apply to Dubai companies and to individuals. And so we would say it's not as simple as the DIFC court in this case saying, well, if the Dubai court can't do it, does that matter? Can I just do it anyway? Can I order the sale of these shares even if the Dubai court can't? We say that if one was to adopt that approach, what you would actually be doing is superimposing substantive concepts of DIFC law in the same way as if the English court in Lencor had declined to enforce the Dubai judgment because it pierced the corporate veil. So in Lencor, if the issue is, should enforcement be refused on the basis that we apply English law English law concepts to decide whether or not Mr. Puri should be personally liable for the company, the court says that's not a grounds to refuse enforcement. If we look at the inverse, the way we say that the Dubai Court of Appeal decision in November 22 interacts with these proceedings, the question for the enforcing court is, can I pierce or pass through the personal status of an individual in order to assert a right against their shareholding in a company? And we would say that if the Dubai court says you can't do that, even if the DIFC court would come to a different conclusion applying its own laws, that's irrelevant, because Lencor tells us the way you have to frame the question is what's the position as a matter of Dubai law, and that's the only question that's relevant to the enforcing court. And like I said, I think earlier in my submissions, to put that in the other way, if this was an Article 7.3 case and the DIFC court has said, I'm sorry, but as a matter of DIFC law, you can't pierce the corporate veil and hold both the company and the director or shareholder liable for something that the company has done. You would expect that if you, as a DIFC judge, issued your execution letter to the Dubai court saying, please execute against the company, that a party couldn't simply try and go and circumvent that sort of decision in the Dubai courts by saying, well, the Dubai courts would have let us do this, so just ignore what the DIFC says. There's built into the Article 7 regime the idea of comedy that Your Honour referred to, which is all you're tasked with doing as the enforcing court is transplanting the judgment onshore or in the DIFC into the other, either onshore or DIFC jurisdiction. You're not exceeding it. You're not circumventing the underlying judgment. You are enforcing within the parameters of what that court has asked you to enforce. And that's how this intersects with the Article 7 prima facie jurisdiction point. Because if the DIFC court's jurisdiction is statutory and it has to go through Article 7.4, which we say it does, it can only assume jurisdiction if it acts within the scope of what the Dubai court says it can do. And Your Honour, that probably brings me on to the final points, which is how you then approach the question of the court's jurisdiction in this case. As we say, it's Article 7.4 and 7.5, and those say that the DIFC court is required to enforce, and I quote here, the judgments rendered by the Dubai courts. And in doing that, the law also mandates that you have an execution letter addressed to the Chief Justice, which says the procedures to be carried out, as well as a copy of the judgment to which the execution letter relates. And the reason that those documents are mandatory and part of this enforcement procedure is, we say, because the law requires the DIFC court to enforce within the scope of the judgment that is actually issued. And we make a number of submissions which tell you what the scope of and the extent of your permissible execution is here. So the first point is the express terms of the execution letter itself. And so there are 2 points to that. One, there's the fact that the case number referred to in the execution letter is 4565/2018. And we also have, on top of that, what we say are 3 translations by 3 different legal translations companies, which have translated amwal to mean funds, not assets. And therefore, we say that there is evidence on its face that what the court is doing, what the Dubai court is doing, is issuing a letter which is intended to carry a narrower construction than the claimant contends for. But to be clear, we don't think that Your Honour actually has to make a positive determination on amwal to come to that view. The meaning of the documents, we say, can also be ascertained from the surrounding context. So given that the enforcement letter refers to the enforcement proceedings and is only 2 months after the Court of Appeal's judgment, we say there's an express link between what the DIFC court is being asked to enforce and what the outcome of those proceedings was 2 months prior. And you have my submission on what the Dubai court judgment said.
Can I just ask you? Can I ask you
Yes.
one question, Mr. Doherty?
Certainly.
There's the enforcement judgment in itself is not what is sought to be enforced. The enforcement judgment is simply saying you can't enforce it against certain assets. The judgment that is to be enforced, regardless of the case number that's referred to in the letter of request, the execution letter, has to be the original judgment, doesn't it? Whether or not I'm restricted to enforcing it against AMVAL, whatever that means, and in light of the various correspondence, is a different point. Surely the enforcement is of the original monetary judgment. That's what's intended. So I'm not quite sure how far this point takes you.
Well, I think that there are 2 points I would make on that. The first is that as a matter of substance, it doesn't change the underlying position, which is even though you're enforcing, if it's your case that you've come to the court and you're enforcing the money judgment, you still have to execute within the bounds of the procedures specified by the Dubai courts. And our position primarily is that the procedures specified by the Dubai courts include a fetter which says you can't enforce against the shares. So that's point number 1. The point number 2 is actually a problem that the claimant has of form, because even if it was intended that it should go to the Dubai courts and get an execution letter for the money judgment, it should have done that, but it hasn't. It's got an execution letter which refers to the enforcement case number, not to the underlying case number. And so if there's an issue of form, it still gives you a jurisdiction problem, because part of the jurisdiction that arises under Article 7.5 is formalistic. You have to comply with the formalities. And if you haven't got a valid execution letter, it means that the DIFC court's jurisdiction never actually crystallizes. So thinking hypothetically, if the claimant were now to go and go to the Dubai courts and say, can you please issue this letter under the subject heading of the Dubai judgment rather than the execution judgment, and then they brought it to the DIFC court, I'd no longer be in a position to make the second point that I've just made to you, which is that there's a problem with form. But I would still be making this submission to say the procedures to be followed still have to take into account the decision of the Court of Appeal that you can't execute against shares. So only 1 point drops away.
Okay.
So that's the express link that exists between the enforcement letter and the enforcement judgment. We also have the point I've taken Your Honour to, which is the scope of the request that was made before the execution letter was actually issued. So that was the 24th of January request. And we say that the fact that that refers to execution against what was permissible for execution in the DIFC means that the request was never carte blanche to enforce against whatever assets you want, but the judge would have had in mind in reviewing that request that I'm only issuing an execution letter which attaches to assets which are permissible for execution. And of course, the Court of Appeal has said that the shares are not part of that. And then finally, we say in case there's any doubt about exactly what it is that the Dubai court meant in its execution letter, we have all of the subsequent letters that the execution court sends to the DIFC, clarifying that any attachment over the HMR shares should be lifted. And so the relevant scope of the DIFC court's jurisdiction, with all of that in mind, did not allow it to enforce against HMR shares. It did not allow the DIFC court to take steps to freeze or place a charge over their shares or to subsequently force the sale. And what we also say is that the basis upon which the claimant has pursued this enforcement action is not only inconsistent with the Dubai court proceedings cited in the execution letter, but is an attempt to circumvent a final decision of the Dubai court on that point. And where that's the case, the DIFC court, this DIFC court action comes into conflict with the judgment that's being enforced. And in those circumstances, the DIFC must be acting outside its jurisdiction under the judicial authority law if it does something not only more than, but contrary to the underlying judgment that's being executed. The second broader submission comes after that. So if one was to say, well, the execution letter is ambiguous, I'm not entirely sure what the execution court was getting at here, and although I'm assisted a little by the request and by the context of the judgment, I'm not certain. What we say about that is that subsequent clarifications were nevertheless sent using the same format as the execution letter, referring to the same set of proceedings. It was sent to the Chief Justice of the DIFC court, and it says repeatedly that you should lift the attachment over the shares. And we say that even if one was to take the view that the 31st of January letter was maybe not clear, those letters should nevertheless be viewed as forming part of the procedures to be carried out for the purposes of Article 7.5a. Because if the execution court issues its execution letter, and then it issues a subsequent letter which says, by the way, pursuant to our previous execution letter, can you please lift the attachment on the shares? What that then does is give rise to a requirement that the DIFC court should actually follow those procedures, because it must be implicit in Article 7.5a that if the Dubai court can specify procedures to be followed, that the DIFC court would be acting without jurisdiction if it actually declined to follow those procedures. Because what the DIFC court would be doing in those circumstances is declining to follow what is one of the mandatory requirements for assuming jurisdiction under Article 7 in the first place. And as I said, the references to those letters that we rely on are 1992, 1998, and 2146. And what it would mean is that even if faced with the enforcement proceedings at the time the ex parte orders were made, the court could have been satisfied at that time that there was enough there to give it prima facie jurisdiction. That actually falls away because the subsequent clarifications are procedures to be followed. And insofar as the DIFC court continues to act in a way which declines to follow those procedures, the only linchpin for its jurisdiction has disappeared. The final point on that is this question of residual jurisdiction, whether, and then this relates to the worldwide freezing order. So the question of if you were with me on all of those points so far, is there a basis on which the enforcement proceedings could fall away, or the party it claimed fails, or the charging order falls away, but you can still maintain a worldwide freezing order against the defendants? We say that the answer to that is no. because the only relevant asset against which execution is being sought are the HMR shares. And if it's right that those fall outside the bounds of the DIFC court's jurisdiction, then there is no subject matter of execution. And without there being relevant subject matter, the other prerequisite I identified earlier in Article 7.4 of the Judicial Authority Law would also fall away. And if that's the case, the orders are made with the worldwide freezing order would not have a jurisdictional hook. And if you don't have the jurisdictional hook, the effect of Sandra holding is you can't get the order for relief. And it's irrelevant that the claimant now seeks to identify a number of potential alternative ways in which it could try and bring itself within the jurisdiction of the DIFC through another gateway, because that really just puts you in the same position of asserting a prospective gateway in the alternative. It's the same argument that was effectively run in Sandra Holdings. I think it was asserted in Sandra Holdings, well, we might have jurisdiction, we haven't got to the bottom of that yet, but you can make the order anyway. And we say that that's wrong as a matter of law. So pulling it together, we say the proceedings are misconceived. We say the claimant's position here requires the DIFC court to agree that it should, or in fact that it must, execute by any means some judgments of the DIFC courts whilst ignoring others. And what the claimant is doing is trying to use the execution jurisdiction of the DIFC court in order to enforce a decision of an onshore court in a manner which expressly conflicts with another binding decision. And you can't pick and choose judgments in that way. It would completely undermine the purpose of the regime under Article 7 if the DIFC court, exercising its enforcement jurisdiction, could do the opposite of what the Dubai court has said it can do as the court which has rendered judgment in the first place. We say the Dubai court was entitled to hold as a matter of federal law that the claimant could not acquire rights over the shares of the first defendant in the way that it purports to, because it's trespassing on a question of personal status, which is a matter for the application of Dubai law. That's what we say about Lencor. And all that the DIFC court is being asked to do is enforce the decision of the Dubai court. The DIFC court can't be in a better position than the Dubai court to decide which of those judgments are relevant for enforcement and which aren't. The execution letter expressly asks the DIFC court to enforce the outcome of case number 4565 of 2018. And if that is what the DIFC court has the jurisdiction to do, it cannot act beyond the scope of what the Dubai court is asking it to do. And it certainly can't enable the DIFC court to do the opposite of what the Dubai court is asking it to do. And it's on those grounds that we invite Your Honour to conclude that you don't have prima facie jurisdiction under Article 7 because you are being asked to do something which the Dubai court has already said you can't.
Yes. All right. Thank you very much. Yes, Mr. Holloway.
I'd like to respond to this jurisdiction submissions in full, and that may take, I won't be as long as Mr. Doherty, but I'll be perhaps more than an hour. The other thing I was going to ask your indulgence was, could we have a short pause, a comfort break for 5 minutes?
Let's take a 10-minute break. What time are you in Dubai? You're 3 o'clock now, are you?
Yes. Well, Mr. Doyle
Right.
was right on time, I think. Yeah, indeed.
Yeah. Okay. Well, let's take 10 minutes now, and we'll see where we get to. If the court is prepared to sit late, I certainly don't mind sitting longer than originally planned.
Very good.
All right. We'll say 10 past the hour then, please.
Thank you, Your Honour.
Yes, Mr. Holloway.
Thank you. So just a preliminary point to begin. I believe Your Lordship asked, there's some confusion about what which actual decision we were requesting enforcement of. And Lord, it couldn't be clearer. We requested enforcement of the Dubai judgment, which required us to submit a copy of that judgment with the executory formula affixed to it, making the application with those documents to the DIFC court and attaching the letter with those documents. But it certainly is not the case that we were bringing the enforced execution court judgment that you cannot sell shares to this court for enforcement. That would make no sense whatsoever.
That much was obvious to me, but the issue then may be an issue of form, because the letter of execution refers to a different case number, which is actually the execution.
Well, that's a complete red herring, with all due respect to Mr. Doherty, but the file name is the execution file of that judgment in the Dubai courts. So when it comes for execution in Dubai, that judgment, we open an execution file. All kinds of things can happen in that procedure, and we know that an expert was appointed, for example. I believe properties and bank accounts were inquired about, and so on. The file is not limited to one decision of the judge. It's the general execution file, and that's just the way it works. If the request is coming from the execution judge, it's going to have that file on it. There's nothing more to that. So just moving back then on jurisdiction, I'm going to just briefly talk about the legal background, very briefly, and then the execution decision, which we've already touched on, the enforcement letter, and the subsequent letters. I'll stick to that structure, or unless you want me to depart from it. And the opening remarks about the legal framework, I think all of the legal instruments, the foundational statutes of the court, stress two things. The first is the independence of this court, and by that is not just meant independence from the parties, but it is meant independence from the other courts in the Emirates. It's an independent system of justice. It's a common law system, separate and distinct from the others. The second point is that Dubai law does not apply in these courts. The federal laws on civil and commercial procedure do not apply here. So we're not limited or hamstrung by principles of Dubai law in many matters, unless the parties have agreed the application of those laws. I'm not going to turn those out. But I'll skip straight now to the judicial authority law, and I'll talk about it very briefly in detail, and then I'm going to come to 7.4 and 7.5 in more detail. But I want to look at 7.1 first, my Lord. That's at page 758. So, key point about Article 7.1 is that, unlike the other articles, it has the word jurisdiction in it. So it says that when you're executing within the DIFC, and we're talking about execution here, is the language of Article 7, not enforcement. The previous language of the old law was enforcement. It is not execution. But when you're executing within the DIFC, it gives you jurisdiction, or the word jurisdiction is used. So when you are looking at Article 7 in accordance with Article 5 and the jurisdictional gateways, you can be clear that Article 7.1 is a provision that is designed to trigger the gateways. It's a jurisdictional provision. There's no doubt about that. And my Lord, if you are the execution judge, that gives you the jurisdiction to execute this judgment in the DIFC if you're of the view that this is a DIFC judgment. And my lords, the order that you made on the 3rd of February clearly states that that is the case. My lord, it's a judgment of the DIFC court. It has become such. I can turn that up, and it's probably worth looking at again, because I want to emphasise there's a big difference here between the enforcement order, the freezing order, and the charging order. The enforcement order is actually issuing a final judgment of this court. That's at page 1241, and my lord, it's at paragraph 2. The key language is enforceable as a judgment of the DIFC. My lord, that's what you decided, and I remember actually having a discussion with you about what Article 24 meant and whether the word ratified was an appropriate word to use. And your lordship stressed recognition and enforcement are the key aspects of this. And that's the order that was made. It's a final judgment in my submission, my lord. So regardless of execution, this is an enforcement order, and these are two separate things. Now, what follows from that is that order simply cannot fall away. That there's no reasonable basis that it could, because nobody in Dubai has ever suggested that the Dubai judgment is not final, binding and enforceable, and none of the letters sent by anybody, any of the applications in the Dubai court, and they've made many applications here to get letters that were to be brought back here in order to sort of see if there's a way around this, but none of them have ever said that the Dubai judgment is in any way questioned. It's being executed in Dubai. There is an execution file open, and it has been recognised and enforced here. And nothing that my learned friend has said gives you any jurisdiction or basis on which that should be set aside at all. So I'll support that, because the DNB Bank case makes that clear, that once a judgment has been recognised in this court and declared enforceable, the execution process that follows that is not the execution of the foreign or the original judgment, but it is execution of the DIFC court judgment. And I'll turn those paragraphs up, and I put them in the skeleton. DNB Bank, it starts at 3121, but the paragraphs I'm going to refer you to are 3138, and so on. So paragraph 105, I mean, this case, you'll remember, my lord, it was an English judgment that was being recognised and enforced in this court for the purposes of being sent to Dubai for execution of the conduit jurisdiction. It's the leading conduit jurisdiction case. And that was all about 7.2 of the JAL, because it was a conduit case. That's not relevant to us. But paragraph 105 clearly states that it starts by talking about you cannot review the merits and so on and so forth. And then paragraph 106 when you're talking about execution here, the judgment being executed is not the English judgment, it's the DIFC court judgment, and that's repeated at paragraph 107. When you recognise and enforce a judgment, the product is a DIFC judgment, which can be executed under the appropriate provisions of the JAL. And in that case, it was Article 7.2 because they were sending it to Dubai. But in this case, for your purposes, my lord, it's 7.1. And it's repeated at paragraph 116 over the page the foreign judgment, once enforceable in this court, once it's enforced, becomes an independent local judgment of this court. And it's 117. It's a local judgment which can be referred to, referred onwards, etc. And then just the other point on DNB Bank, if I need to make it, is in answer to what my learned friend said about the assets and the freezing order. And that argument has been completely ruled out since DNB Bank in 2015. Enforcement does not require assets in the jurisdiction. So when we're talking about the enforcement order, it doesn't matter that there are no jurisdiction, there are no assets in this jurisdiction. What matters is that assets might come into the jurisdiction, or when you have this enforcement order, you can have the mechanisms that go along with that, which help you find out where the assets are. And that's paragraph 125, 126 and 127. They talk about the Traxis Australian case, and they say enforcement and execution, two separate things, doesn't require to have assets in the jurisdiction. And 127, they talk about the Banyan tree case, Maidan and Banyan tree. Absence of assets are irrelevant at the execution stage because they may come into the jurisdiction afterwards. They may not even exist at the time of enforcement, but the enforcement order is of value of itself because it can give you the assistance of the court's machinery, for example, charging orders, etc., and specifically mentions freezing orders. So the assets point is the non-starter. 129, they also add that actually when you're making the enforcement order, you're not concerned about execution at all, because what other courts do with the judgment is not this court's business. And I think that the point should actually operate in reverse. It's really an independent process. Well, and also we have to bear in mind the reality of this case is where are the assets? Well, we don't know that, do we? And my Lord, you've made that point very clear in your committal order. But there's no suggestion that the judgment is under threat in Dubai that could possibly be challenged. And there's no suggestion that any Dubai judge is trying to tell you that you should not enforce this judgment as a final and binding judgment. So it follows from what I've said that the execution jurisdiction that you have, my Lord, comes from 7.1, not 7.4 and 7.5, and that is emphasised, reinforces your independence to apply IFC laws and procedures to execution, which is a different thing from enforcement. But I'll move on to 7.4 and 7.5 because that's what Mr. Doherty's placed the most emphasis on. The first thing, if we can go back to that, I think it's 7.5.9 that I'd ask you to look at, my Lord. Look at just to look at the difference between the wording of Article 7.4 and the wording of Article 7.1. The first thing I'd say is you don't see the word jurisdiction in Article 7.4 at all. My learned friend keeps talking about the Article 7 gateway to jurisdiction, but that's not correct. The provisions about jurisdiction in the JL are not found in Article 7, they're found in Article 5. And the question is, can you put Article 7, each one of its subsections, together with Article 5.1a or 5.1e to make a jurisdictional gateway? Now, you can with Article 7.1 because it clearly says you have jurisdiction to exercise in the DFC. But Article 7.4 doesn't say anything about jurisdiction. It says the conditions for execution are subject to the following conditions. Number one, that the judgment is final, that the executory formula is fixed to it, and that it's translated. Although there's no dispute, even if this were a jurisdictional requirement, nobody's ever said that those requirements have not been satisfied, because they have been. You see it at page 11 of the bundle. The judgment is stamped, it's translated, etc. So Article 7.4 as a jurisdictional objection just doesn't work at all, because it's not a jurisdictional provision. And I would say the same about Article 7.5. You see, again in Article 7.5, there's no mention of jurisdiction at all. It just says the following things must be observed. It does have mandatory language, I accept that. But it says, and I think the only one that they're relying on is 5A, there has to be an execution letter stating the procedure to be carried out. Well, there was a letter, but I'll come back to that. This is not a jurisdictional requirement, my lord. It's a procedural requirement, and that takes us back to Sandra Holdings, everyone's favourite case, because if you look at that, it makes it clear the kinds of things that a jurisdictional requirement provision needs to have. So, for example, I'll take you to this because I think it's completely on point, actually. It's paragraph 45 to start with, at page 2628. So, well, tell me if you have it, because I know the system doesn't work very quickly. But
Is on mute.
and you're on mute, Muller, at the minute, so
If you could ask him to.
yes. So, the submission made there was about, you know, the Muller, I think if you do mute yourself, it's causing a lot of feedback for some reason. But
I think it's your end where the feedback is.
It seems to happen for us when you're not on mute, but it may be the other way around for you. I'm sorry.
You're right. I think what's happening is that when Mr. Holloway speaks, it comes off your speakers, and so you can hear him clearly, and it reverberates to the two of us. But I think that's fine. I can still, well, for my part, I can hear what Mr. Holloway's saying. I think he probably knows the words that are coming out of his mouth, and as long as you can hear it, I think we can probably crack on.
Okay, that's okay. So, yes, well, the appellants there were saying that Article 25.25, the one which says if you want to get a freezing order in support of foreign proceedings, it must be by Part A claim. And the court ruled that out, and of course they said that's a procedural rule. It only tells you how these things should be done. It doesn't talk about jurisdiction. No, it's the same as Article 7.5a. It's not a jurisdiction provision. It tells you how to do things. Coming to my learned friend, I'm afraid if you're relying on Sandra Holdings, you shouldn't be able to pick and choose the bits that you like. But that's not a jurisdictional provision, and that's the structure of it, as far as I can see, my lord. And I'll move on to the execution decision then. My lord, you picked up on a lot of the points that I was going to make, but I'm going to repeat them quickly. I'll move to the Court of Appeal decision rather than the original one. We've talked about this, but let's put this up again. It's at page 382. And like you said, my lord, I think it's important to work out what this judgment does say, what it doesn't say, and what it can possibly mean. My lord, my submission is we don't need any further delays or adjournments to work this out, because whatever it means, it doesn't preclude your lordship from taking jurisdiction in this case. Well, it's certainly not relevant to the jurisdictional issues, unless for some reason you could possibly interpret this to preclude your lordship from doing anything, and it just simply cannot go that far, my lord. So first, what it does say, as you've picked up on, my lord, it says the finding is that HMR Investment is a private company, not a limited liability company. And, my lords, we don't know why they've decided that, but they have. But then it says, therefore, the provisions of 81 are not applicable. And then it says, rather, the provisions of Article 20 of the same law. So that's what it says, and I'll come back to the company's law. But what does it not say, my lord? What could it possibly, couldn't possibly be interpreted as saying? It doesn't say that shares can never be sold, because the words as such limit that finding to the previous finding that they cannot be sold because it's not a limited liability company. That limited liability company is a precondition for the application of 81. That's the only finding, and the as such means that this decision doesn't say you cannot ever, these shares are not capable of being executed. It doesn't say that. It says it is not a limited liability company, as such the shares cannot be sold. So that's point number one. Number two, it doesn't preclude further attempts to sell the shares, for example, under Article 20 or any other execution mechanism. And then further, it doesn't say anything about capacity of the parties at all. It doesn't say anything about personal status of the parties at all. And it doesn't say anything about piercing the corporate veil. It's completely silent on that, and that's because none of those issues were in any way before the judge. So what does the judgment mean? We do have to look at Dubai law to work that out. But, caveat, you're not bound by Dubai law and you're not bound by this judgment. But when you're working out what it means, we can look at the commercial companies law, and I do want to take you there, if I may. It's at 3423. The first part of it has some general provisions, and I'll point to Article 5 here. Sorry, there's a lot of preamble, but it's at 3427. Generally, this law, even in Dubai, doesn't apply to free zone companies like HMR. Now, there is an exception if that company has got specific authority under its license to conduct activities onshore Dubai. We've seen the license of HMR, it doesn't say anything about that. But in general, this law is not supposed to apply to free zone companies at all. And my second.
Where do we see that in the statute?
It's in Article 5.1, page 3427.
Yeah.
It's not quite as simple as that. There are exceptions for companies that who have explicitly got on their license trading on the onshore, and we've not seen that in HMR's license, but we may be wrong. But that's one general point. And then, because Article 81 is all about rules applicable to limited liability companies, there's a special part of the Act about limited liability companies. That's part 3 of the Act. It's from Article 71 onwards. And that's where we find Article 81.
What's the difference between a limited liability company and a private company for the purposes of this statute?
Well, there is no, as far as I know, there's no term of art as to what a private company is in the Dubai Companies Law. They have specific kinds of companies like limited liability companies, partnerships, limited partnerships, and so on. And what they've done is HMR, because it is a DIFC company, is called a private company because that's the way the DIFC classifies its companies. So they have said, I don't know.
Meaning an unlisted company, so far as we're concerned.
Meaning, yes, public versus private. These would both be limited liability companies as we would understand it. But here, there are specific rules for different kinds of companies. And we don't quite know why the judge has decided that it is not a limited liability company. It may have been that he decided that because it's not an onshore company, the action shouldn't apply at all. We don't know, but that probably contradicts with the finding that Article 20 does. But what he said is specific rules in Article 81 to do with limited liability companies don't apply here. And then if we can look at Article 81, Lord, it's 3442.
Yeah.
3442, sorry. It's not quite a straightforward mechanism here, because what Article 81 says is that basically you can get the execution judge to auction shares of the company, and then if the other shareholders agree, they can preempt that by buying out the shareholder. But there's a direct mechanism where the execution judge can do that. And the execution judge said, I can't do that because this is not a limited liability company.
When it refers to the equity stake, what does that mean? I mean, is that talking about the assets of the company in his proportionate, quote, his proportionate share of the assets of the company, or is it actually talking about his shareholding in the company?
Well, I think it probably goes beyond the just shares. I think it does seem to suggest it's the interest in the company, whether it's shares or whether it's not. I don't know. Shares, I think, would be the natural reading of it, because if it's a limited liability company, the equity stake would probably be the shareholding. But
yes, well, that's the oddity about then looking at this as, quote, a private company as opposed to a limited liability company. But anyway, there we are.
But
that's
then,
what our 81
yes,
says.
But then what it also says is that rather Article 20 does apply. That's in the more general provisions of the law. And I'd like you to look at that as well, my lord, if before we move on. It's 2432. You've looked at it already, I know, but sorry, is that, am I right? It's 3432. No, it's 3431. I beg your pardon.
Yeah.
So that, again, it's slightly even more complicated, I believe, but the first part, as we've seen, doesn't align the interest, companies' assets, and but Article 22 is the bit that is interesting, because this is the bit the judge said this provision does apply, and it says if the interest is shares, it can be so. The difference between Article 20 and Article 81 is that you have to apply to the competent court for selling shares, whereas under Article 81, I believe the execution judge can order the auction, and then the partners have the right to buy those shares before they're sold on. This one seems to say you can ask the court to just simply sell the shares. And we're all, the detail of this may or may not be right, but our reading of this is that the execution judge was, I'm not competent to order an auction of these shares. You can apply to the competent court for them to be sold. And he may have come to that because he may have thought, I'm not the right person to sell these shares. The DIFC court might be the right person to sell these shares. That's an obvious reading of it based on the fact that it's a DIFC company. But it certainly isn't because that the judge said there's some sort of general preclusion to selling the shares. Because if 1620 applies, it also has the right to sell the shares. There's an extra step required. But even on the reading of that judgment, it doesn't say that the shares can never be sold. It doesn't say anything about personal status. It doesn't say anything about piercing the veil or capacity. And I just, on that point, I don't understand. I think it's wrong what my learned friend has said in his skeleton, because he says that paragraph 70 that there's some distinction to be drawn by Mr. Rashed in his personal capacity, in his capacity as owner of a company. I don't think there's any legal distinction whatsoever. I mean, what's happening here is that Mr. Rashid's assets, shares, are being sold. There's nothing to do with the company's assets. Nobody's ever done that. So that submission, I believe, doesn't make sense. And so that's the factual position of the judgment on its face and the Dubai law. And you know why the judge made these decisions is actually neither here nor there, because what you're being asked to do, Lord, is to say that 9 months after a final judgment has been made, you're being asked to find that you've been precluded from making that judgment by this decision of the execution judge. We don't need any more evidence on this. It just can't be the case. On the text of it, on the plain face of it, or under Dubai law. And then the final point on that is that execution is a procedural process. It doesn't create substantive rights about or decisions about personal status and so on and so forth. As a basic premise, you can see that by reason of the fact that the Court of Cassation is no longer allowed to decide execution decisions. They don't throw up questions of substantive law at all. And that's why when Mr. Muhtasab is preparing his witness statement, he had to find really old cassation precedents which established that position clearly and which led to the fact that the Court of Cassation is not involved in this anymore, because it's not substantive law at all, it's procedural. You can see that, Lord, from the English case that we've cited, Investbank and Husseini, which we mentioned briefly in the skeleton. We want to turn back to that, if I may. So 3144.
I'm finding it very difficult to hear you at present, Mr. Holloway.
Well, I believe when we are both not on mute, we are feeding back to each other. So I don't like to ask you to mute, but if you mute when I'm speaking and I mute when you're speaking, then I think we can. Sorry, please interrupt me whenever I'll mute myself. My lord, I'm going to just turn to the Investbank case because I think we don't even need really Mr. Muhtasab to confirm this. The English High Court has confirmed it on a UAE case with the benefit of UAE expert evidence. It's at 3144. The first bit I'd like to take you to is paragraphs 12 to 15. And that, my lord, I won't go through it, but it briefly sets out the background to the UAE law on execution. Now, what was going on in this case was that an Abu Dhabi judgment was being enforced in England, and the execution judge in Abu Dhabi said, I'm not a lawyer, I'm not executing this judgment. And there was also even more than that, there was a law in Abu Dhabi that was passed after the judgment saying you cannot execute these judgments. The English court said that's all irrelevant because those are procedural matters of execution in Abu Dhabi. And further than that, it was pretty much agreed by the UAE law experts in that case that under UAE law, execution decisions are procedural and do not create substantive rights. And there's some general background on the UAE legal system there. Paragraph 15, the execution phase starts after judgment, etc. Really, the point of this is when we get to the res judicata points, my Lord, because this decision clearly shows that execution decisions at the site of where the judgment came from should not preclude anything happening in the enforcing courts, outside that jurisdiction. And my Lord, we've quoted that in our skeleton, but can I just take you to paragraph 37, which is just a couple of pages down. It's 3149, I believe. Yes. Importantly, this was not disputed by either side's expert, the procedural nature of execution judgments, but it clearly says these are procedural in nature, not res judicata. The execution creditor can seek execution in more than one way and on more than one occasion. So, and then, I'm sorry, I will take you through the rest of this judgment because it's very helpful in terms of the common law analysis to execution and enforcement. So, and if you look at paragraphs 40 to 62, I'll not go through all of it, I'll take it quickly. But the point that's established in these paragraphs is that a judgment is enforceable even if it's not executable at the jurisdiction of its source. And I'll skip forward to exceptions to that rule, which are dealt with at paragraph 51. This is a very detailed analysis of the conflict of laws and the enforcement rules, my Lord. There are exceptions to this rule. If a judgment has been stayed pending execution,
can I just ask where this is in your skeleton?
my Lord, I've referred to the case in the skeleton on the point. Let me just turn it up. I refer to paragraph 34 of the judgment, my Lord. So sorry. Bear with me, my Lord. I'm so sorry. It's paragraph 48. That's page 3066.
Yes, thank you.
So yeah, the point really was, yeah, the judgment is final binding and res judicata, but the execution things are not. But it is clarified a bit, perhaps more clearly in paragraph 37. And then, but that's the basic point, my Lord. But it's a procedural decision. It's not res judicata. It can be reviewed. It's interim, etc. And then there are exceptions to that, to the idea that things that happen at the court which made the judgment can affect enforcement elsewhere, but these are not, this case doesn't fall within any of those exceptions. So, for example, there are cases where the judgment has been stayed by the court that made it pending execution, and that gives rise to an equitable claim, perhaps for a stay of execution overseas. But this is not the case here because the judgment has not been stayed. It is still enforceable and binding. And actually, in paragraph 51, Stephen Houseman, KC, the judge, said the reason for those cases is that there's a question mark about the finality of the judgment itself, which allows the court to say, well, hang on a minute, let's wait till the appeal happens because things may be difficult to unravel. This is not one of those cases, my lord. The other example given is paragraph 54, and that clearly illustrates the point. Adrian Briggs's scholarship, but he's found cases where the court that made the decision has said, well, you've got 21 days to pay. And under common law, that doesn't matter because the judgment is immediately enforceable. He says that's one of many examples where you can get, the creditor can do better abroad than it can at home. There's nothing wrong with that at all. And then paragraph 55, they specifically say, okay, the Abu Dhabi courts have applied local law, and that local law, they have to apply it. It's mandatory in Abu Dhabi. But it's practical and procedural. It doesn't alter the res judicata effect of the judgment, and it doesn't make enforcement outside Abu Dhabi contrary to public policy. And then finally, just to be complete, paragraph 56, there are these cases where the judgment is conditional, and that's Nuvian and Freeman and so on, where the judgment itself isn't final because you have to go through another process to make it final. This doesn't apply here at all. And then, so what that means is, going back to this point, is that there's no problem with executing in one place and the other, and one decision doesn't preclude you doing the same thing in the other. They're two independent things. So a judgment creditor can seek execution of the debt in more than one way and on more than one occasion. That is also consistent with JJC case law in this country, my lord. So there have been JJC decisions saying that there's absolutely no reason why you can't execute one place and the other at the same time. The only qualifying point is that you can't get double recovery, and you know we're lucky to get a single recovery here, but we're doing our best. The same point made by Lord Glennie in the J Trust case that we've cited as well is no reason why you should not have enforcement in more than one place. That's at page 3365. It was a Dubai DIFC case. So if any of that's in doubt, Mr. Muhtasab's evidence repeats it, clarifies it, reinforces it. My lord, if you've admitted the evidence, but he's cited two causation judgments saying the same thing. So then just the final point, Mr. Doherty relied on the civil procedure law in Dubai, Article 222. And my lord, I think what he said on that is mistaken. It's at page 3085, and it's in his skeleton at paragraph 37 and 38. But that provision says only one thing. It's the reciprocity requirement in Dubai for enforcing foreign judgments. So basically, the Dubai court will not enforce an English judgment if the English courts will not enforce a Dubai judgment. That's all it says. And rather than this being consistent with the DIFC approach, it couldn't be more different. This is one of the big differences between Dubai law and common law. Reciprocity is a requirement for enforcing judgments. We don't have that requirement, but that's not to do with individual judgments. It's a general rule about enforcement in judgments from one state. If there's any limit in the law of the other state, which would limit you enforcing Dubai judgments, then you can't do it. So that's really what that means. It doesn't mean that you have to, when you're enforcing this judgment, be bound by what the Dubai judge would do if he's enforcing the judgment. It doesn't mean that at all. So just a final postscript to this, my lord. Your freezing order. If I can turn you back to that, page 1245, particularly paragraph 5. Lord, paragraph 5 said that freezing order was ordered to be made as enforceable directly in Dubai. And your Lordship may remember we asked you how that worked, and the registry was directed to write a letter in the order to the Dubai courts that your order would be enforced onshore in Dubai. The whole point of it was to protect against these properties being dissipated. And, my lord, that order was enforced in Dubai. It was taken on shore and it was enforced by the Dubai execution judge. And Mr. Basiso says this in his third affidavit, paragraph 13, page 12, 1299 and 1300. So that order has been taken to the Dubai courts and it has been enforced. One of the things that they've done is that they have attached those properties that had been originally dissipated into the DIFC company, which owns them now, whatever. But no attempt has been made in Dubai to suggest that that freezing order was made without jurisdiction, and the execution judge plainly doesn't think that it has, because it remains in force. So the strangeness of Mr. Dawley's position is he's saying you really don't have jurisdiction to make that order because the Dubai execution judge, it's completely contrary to what he has found. On the other hand, the Dubai execution judge has accepted your order and enforced it to execute against properties, and nobody has ever suggested that he can't do that or shouldn't do it. So that's all I'm saying on the judgment, my lord, the judgment not to sell the shares. It just can't possibly have any effect on your jurisdiction at all, particularly with the enforcement order. It doesn't say anything about the enforcement order, and nobody's ever suggested in Dubai that this judgment is not final binding and should be enforced. So if we're looking, at best, it goes to the extent of how you execute that, but the enforcing order has to stay. The freezing order, how could it possibly be contrary to the Dubai execution judge when he's executing it? It doesn't make any sense. Now, the other practical points are, just pausing for a second, if the enforcement order of this final and binding judgment is set aside, or the freezing order is set aside, there'll be nothing stopping them doing exactly what they did the first time. Whatever assets they have, they could just put into the DIFC to avoid executing the Dubai judgment. Now, actually, there's a point on this, because Mr. Rashed's evidence actually discloses some more properties. Paragraph 6.5 of his statement, I'll have to turn this up if you bear with me, but it's he says, when he talks about service not having taken place, one of the things he says is that I own many properties in that building, and it's paragraph 6.5, I believe, 1822. Now, we've never seen anything about those properties. They've not been caught by the Dubai execution judge executing the Dubai judgment. So we've no idea, in what capacity he owns those assets. But the freezing order will cover those assets. And if it was set aside, 6.3, my lord, I'm so sorry, it's 6.3, page 1821. I own multiple properties in Alpha Town. We don't understand that. But if you were to set aside the freezing order or the enforcement order, he could do with those properties what he did with the other ones, which is dissipate them. I appreciate that's a discretion point, my lord, but it's. Well, that was all I was going to say about the.
Where is Al Fatan? Is that in onshore Dubai?
It's in onshore Dubai, just by Dubai Marina.
Oh yes.
Yeah. And well, that was all I was going to say about the judgment. But just coming back to this idea that we need more evidence on this, we don't. Mr. Doherty has had plenty of time to prove to you why this judgment precludes you from either enforcing the Dubai judgment or executing it. If he hasn't proved it by now, we're just wasting time having more arguments on this. Whatever way you interpret that judgment, it just doesn't preclude you from doing anything. That would be my submission. Well, I'm going to just leave that point. And now I'm going to move on to the letter. And briefly talk about this Amwal point. Well, I think the basic point here is that Mr. Doherty's argument is not that it means funds instead of assets. What he's trying to say is that it means, in paragraph 54 of his skeleton, it can only mean money or cash, and that just cannot be right. And we look at actually the evidence on this. Well, you simply cannot be convinced that this translation was anything other than the original translation submitted to the court, which is at page 8. Really, you cannot be satisfied that that was wrong, or that there's anything wrong with that translation, and I'll tell you why now. First is, the only reliable evidence you've got on that is from Mr. Besiso, and what he's done is actually give you the dictionary definition in Arabic translated into English. So he has exhibited that. He's not giving evidence here. He's a bilingual native Arabic speaker. He's not saying giving evidence, expert evidence on translation. He's given you the dictionary definition of Amwal, and you'll see that it does mean property, general word, property, asset, all kinds of property. That's 2123. This is a translation of when like the OED version of Amwal, the meaning of it. Property. And then.
Hold on, I'm not there yet.
Sorry.
This is exhibited to Besiso, is it?
Yes, Mr. Besiso's third affidavit when this issue came up. So when it came out, it was raised by Mr. Rashed in his set-aside application, or his first evidence, and this was Mr. Bissell's response. So it has a range of, it's a very general word, it means a range of things, but it, it's translated as property, and it includes all of the things there, real estate, physical properties, etc., that connotes assets in my submission. Now, that's our version of what it means, and that's what the original letter submitted to the court says that it means. The only other evidence you have on that, the only actual evidence that you have, is from Mr. Rashed. And the problem with that is that Mr. Rashed doesn't speak English, so he is not qualified to pronounce on the various nuances of the alternative meanings of Amwal and so on and so forth.
Is it the same word in Farsi?
I don't know that more. We could probably find that out, but I know you've had occasion to decide that. What I would say is that if it means assets, then yes, it is. But
well,
I disagree. But
one should never rely on one's own recollection of other cases and knowledge supposedly gained. But there was no issue. There was no issue in the case that I was involved with that. If it was the Farsi word as opposed to the Arabic word, that's what it meant. But I won't rely on it.
Put it this way, it probably could mean funds, if that's what you were talking about. It could mean money, it could mean anything, but it means, the real meaning of it is property or assets. That could be money, that could be property, it could be, and so on. Now, I think the point I'm trying to make is you've got two pieces of evidence on that. You've got Mr. Basiso and you've got Mr. Rashed, and Mr. Rashed just cannot give credible evidence on that point. Second point is, Mr. Doherty's made submissions on this in his skeleton argument, and he's given you the website that Mr. Basiso used, and that's at paragraph 55B of his skeleton argument. And he says, using that website, the word comes up to mean cash, money, and funds, etc. And that's an attempt to say that that's all that it means. But actually, I'll tell you, I've clicked into that link, and what that skeleton argument has omitted is the first thing that comes up on the list of things that is meant by Amwal. And the first thing that will come up, you'll have to type it in to verify this, but the first thing that comes up is something that belongs to you. And then it has a list of different things. Yes, it has cash, money, and funds. It also has equity, wealth, immovables, realty, fungibles, assets, and property. So that website is not in any way saying anything different from what Mr. Basiso's evidence said. And then finally, my Lord, if you do have time to do this, you click into Mr. Doherty's website, type in the word asset, get it to translate to Arabic, and it comes up Amwal, funds the same. So that doesn't take things any further at all. What you're being asked to find here is that the translation that we doesn't mean what you say it means, and there's no evidence to suggest that, Lord. What then Mr. Doherty says is, well, you've got to look at the context of it. He actually says it doesn't really matter what it means, and I think he sort of accepts that it does mean assets or funds. And he's saying if you look at the context, then it does mean something different. But I think, Lord, I submit they're wrong on that, because if to the extent that we have to embark on a discussion of meaning, the context could not be more simple. We're trying to enforce a judgment here. Why on earth would we want a letter that says cash? And also, well, why would the judge write such a letter? Because that would, if Mr. Dolly's saying, well, you can't have the shares, that doesn't mean you can only have cash. It doesn't even mean that you can't have shares in another company or properties in the DIFC. So why would it be limited to cash? It makes absolutely no sense. What they've done is they've come up with an alternative meaning that helps. And this came from Mr. Rashed's statement in September. I don't know who wrote that. And they've latched onto that and said it was all, we've been accused of misleading you, more on that. And I take exception to that, I have to say, because the evidence could not be clearer. It's a general letter. We're trying to enforce a judgment. That's where it is. So the letter, my lord, satisfies the test, whatever way you look at the test. The first thing I'd like you to look at is what is the test, not for execution, but for enforcement. And these enforcement decisions between Dubai and the DIFC happen frequently, and there's a protocol for that, which you find at page 1216. I've referred to that in the skeleton, but that really doesn't say anything about the steps that are being taken and so on and so forth. It's at 2C, my lord. So that's the procedure for enforcing a judgment there. That's the procedure that the courts follow. But even if you were to find that Article 7.5 of the JAL imposed much stricter requirements of the letter and it had to state the procedures, it does state the procedures. We were asking you for an enforcement order, and the letter asked that you execute assets up until a certain value. That's exactly what it is. You can't. You can't say that you can't rely on this judgment to say that you have to deconstruct that letter and say that it means something completely different from what it says. So the evidence on that just isn't at all convincing. So I'll leave it there with the letter and Amwal, my lord, but you don't have any evidence that is in any way strong enough to say that you were misled or that letter doesn't mean what it says. So I'm finally going to turn to the other events after the letters and so on and so forth. And yeah, the first thing is, as I've said before, since March last year, they've embarked on this campaign. They've not taken part in these proceedings, as your lordship knows. There have been a series of applications and requests, both to the registry and to the Dubai court, for letters saying this and that and so on. But what's never happened is that anybody said that original letter, which gave rise to the enforcement and these proceedings, should be withdrawn or should not be used. And you'll see that from the letter, from the last request, the document that was admitted this morning, the very end of the bundle, the final attempt to get the Dubai judge to save the day, say, please don't let them execute against the sharers because it's contrary to your decision. And I think the Dubai execution judge has had enough of this and said no. So that's, and further, none of the applications in Dubai, none of the letters that have been written say anything about the judgment not being enforceable or that should not be enforced. So they don't go anywhere to the enforcement order at all. But then, thirdly, now, what they did do, and what he's saying that these letters, this correspondence says, is not quite right, my lord. The first thing is, they're trying to give these letters meaning that they don't have, in the same way that they're trying to elevate that Court of Appeal decision to have a meaning that it just doesn't have. But I think if we start at the very beginning, yes, page 310, I'm going to have to take you to some of these letters because they don't bear the construction that's being put on them. 310. Actually, I'll start the page before 309, and this is March. And it's a letter from the Dubai court to the DIFC court, to the DIFC authority. I beg your pardon. Well, it's important to actually look at who these letters were sent to, but they have asked to attach the shares and profits of HMR. And you'll see that that letter clearly mentions the company HMR Investments Limited. So that letter is directly asking the DIFC court to make an attachment on that company. But that request was refused, well, declined on the next page. And I think this is where the whole misunderstanding comes from. But we'll go through it, Mahmoudi. So the DIFC courts have replied to that letter. They've said the DIFC authority has passed us this letter, and we'd like to tell you what we've done. Number one, we've suspended the service of, can you see it?
It's muted.
Oh, sorry, you were muted.
310.
Yes.
Yeah.
That's the reply from the court. It's spoken to the DIFC authority, and they're confirming back to the Dubai court. Number one, that we have cancelled the service requests for that company. So the company is now not allowed to actively, use the procedures of the DIFCA. It is limited to license renewal and so on and so forth. That's a very technical thing that the DIFC authority has done. Mark something on. The second thing they've said is that the DIFC authority cannot attach the assets. HMR. The shares, sorry. The next letter I will take you to is 2094. Another letter in December 2021, and they've said, can you tell us, DIFC authority, what the mechanism would be to sell shares? Can a DIFC company be sold by public auction via the Dubai court? And then that letter, again, the court responds, February 2022, 2096, 2 pages down. The DIFC court, again, they talk to DIFCA, the authority, and they say we don't actually have that sort of mechanism to do that. After that, the Dubai court appointed the expert to value the shares, and we've had a look at that. And then in July 2022, the Dubai court decided to sell the shares. I think on the understanding that the DIFC court could not do such a thing, or didn't have a mechanism to do that. That's is at 378. That was, we've looked at that. That's the share sale, the original decision to sell. Now, there have been.
You're going a bit too fast at present.
I was trying to skip past those because we looked at it before.
Okay.
All right. The next one is in September 22, 1966. Well, that is something that Mr. Doherty referred to before. It's important to note, number one, that letter was not sent to the court or to DIFCA. It was sent to my financial market. Stock exchange, if you like, my lord.
Right.
What was going on there? It's got nothing to do with HMR. It's not even mentioned in that letter. That letter is simply asking the stock exchange, does this judgment debtor have any shares listed on your stock exchange? Sorry, it's replying to the letter written to them saying, sorry, it's asking, yes, excuse me, it's asking them, are there any shares listed on the market for this judgment debtor? Not relevant at all, because it's got nothing to do with HMR. And then my learned friend talks about there's another pair of letters in September and November. And I want to take you to those, 2021 and 2022. Sorry, it's 21102 and 2101. And actually, my learned friend talked about this letter, but if we can go to the second one first, 2102, because that's the first one in time.
Yeah, what is this saying?
Well, what it's not, it's got nothing to do with HMR, my lord. It's asking for some sort of limitation on Mr. Rashed's trade license. So it's got nothing to do with attaching HMR shares at all. It's a letter that's relied on by Mr. Doherty to say that everyone should have known that the share attachment had been lifted and so on. It doesn't say anything of the kind. It doesn't mention HMR. And then the reply to that, which is follow-on letter, it's that. So that letter is a response to the one we've just looked at, or a follow-on letter from the one we've just looked at. So again, the first letter in September was saying attach or mark a notice on Mr. Rashed's trade license, and the second letter saying don't bother. Neither of them mention HMR or any shares at all, so it's not relevant to the idea of attachments being lifted and so on. Right. So at that point, there were no attachments in place. There was an original letter talking with lots of letters casting the net to see if there was anything that might work, but there's nothing at the time. There's no attachment in place. Now, I think there may have been some misunderstanding going forward from that, but there are 3 further letters afterwards. My learned friend then says, well, now the court is asking to lift the attachment. And my lord, I'm going to deal with them. They're at page as far as 61B of the skeleton argument. So he says there are 3 letters that requested you to lift the freeze, being the freezing order. And he says those are the letters on the 1st of August, the 15th of August, and the 18th of September. And they just don't say that, my lord, at all. So they're not relevant to the freezing order, whatever they mean. I'll take them in turn. And I'll start with the 1st of August letter. It's the Doherty's translation of the letter. Don't disagree with it. It's at page 1992. Even that translation was an attachment. It doesn't say freeze. Simply doesn't. And the second,
what is this saying?
well, what it is that since all of last year, they've been making technical requests to the execution judge to do this and to do that, and to write to you and to write to the court and so on. But it doesn't mean lift the freezing order. It can't mean that, because an attachment, which is the word that is used, and it's the Arabic word that's used in all these letters, is the same. It is not the same. They're referring to their own procedures, perhaps in the mistaken belief that an attachment had been effected by the court under the original request, letters and so on. But it doesn't say freeze, is my first point. And even their translation doesn't say that. And attachments and freezing orders are very different things. Well, they just are.
I understand that, but do they understand that?
Whether they do or don't, they are working within the confines of their system. They are managing an execution process in the way that they would if they were talking emirate to emirate, trying to find a way to enforce the judgment that's consistent with Dubai. But they're not telling you to lift the freezing order. So my point is simply that you haven't been told to lift the freezing order.
But why are they asking this?
Because
Can't hear. I can't hear you.
Sorry, every time they make one of these requests to the execution judge, they bring the Court of Appeal judgment to them, and he has no alternative to say that what's going on, from my perspective, needs to be consistent with that. So that's simply it. It's attachment and freeze are different things. So it is consequent on your findings as to what that judgment means, because that's really what the letters are saying. The second one, the 15th of August one, again, now their translation does say freeze, but ours says attachment, and the original Arabic is the same in both of them. And the third one, the 18th of September letter 2146, their own translation says lift the attachment, not the freeze. Sorry, it doesn't say that. Let me just turn that up to you, please. 2146. Mr. Doherty says that this letter is telling you to lift the freezing order. And you'll see it just doesn't say anything of the kind. It's asking for information. and I believe that letter was answered by the court, which led to Charles' speech. He's writing a long letter saying that the court hadn't answered the letter to their satisfaction, and proposing that a new letter be written to the court which helped them in their with their strategy. And the court said, we've answered the Dubai court. So that's that. That cannot be interpreted as a letter telling you to the prison or whatever way it's read.
Did you say there was no reply to any of these from the court, the IFC?
The IFC court replied, I'm not sure if this is in the bundle, but it said, we have imposed a restriction on the trading license of HMR, and that's it. I think the reply came from the court through DIFCA to the Dubai court. And I think, perhaps if I can turn it up, that really didn't make my friends on the other side happy, because they wrote a complaint to that. 2296. Sorry. Bear with me. That's the page. Bear with me, my lord. I'll turn this up. It is important. It's 2304. Well, it's probably worth reading that.
Yeah.
So, I'll conclude on this, but I think what's going on is perfectly plain, and you saw it at the return date itself. 2 days before that return date, we were notified that an application had been made onshore to try and set these, to try and get some order from the onshore courts to undermine your orders, my lord. And since then, there's been a sort of guerrilla warfare campaign in the onshore courts, trying to manufacture and generate documents from the poor execution judge who's trying to execute the judgment. And even when letters are not good enough, we're getting pressure from the lawyers here, and one can only imagine what's going on over there, to draft letters that are of more assistance. And where it comes to a conclusion is today, where we see yet another attempt onshore to get the execution judge to write something to you to say that but he's dismissed that 2 days again before this hearing. So those letters, the original execution judgment is not preclusive, and it doesn't mean what they're trying to say it does. The Dubai execution judge may interpret it through his own lens, but those letters simply follow from that. But we're back to where we began. Nobody's ever asked the Dubai execution judge to tell you that you can't enforce this judgment. So that cannot move. And the Dubai execution judge certainly hasn't said anything of the kind. Now, that's the arguments fall away. They certainly fall away as to construction of jurisdiction matters, or to the I appreciate we are late, and I'm sure both of us have lots more that we could say about this case, but it may be, I think just if I could make one final point, Lord, my skeleton argument at section E made a series of submissions to the effect that there's no legal basis for this application at all. Or D7, and I'm not going to develop those submissions at this point because of time, but briefly, I would say that that applies just as much to a jurisdictional question as it does to any of the other arguments. And I'm not going to develop those, but I say that for two reasons. Sandra Holding was an appeal. It was not an application to set aside a final judgment. It was an appeal against a decision on a freezing order. It doesn't say that when you have a final judgment of this court, it can be reopened a year later in jurisdictional questions. So I'm not going to make those points unless you want me to, because they're in the skeleton. I strongly submit that the enforcement order cannot be questioned at this point. Holdings sorry, as I said in the skeleton, our submission is that all three of those orders should be construed as final orders. The freezing order we can debate a bit more, I guess, but I'm not going to say any more about it at this stage unless your Honour wishes me to. So that's my submissions on the prima facie jurisdiction point. I'm sorry I've overrun.
No, not at all, Mr. Holloway. You've been very succinct. Yes, Mr. Doherty.
Yes, if I may just come back very briefly on a couple of points. Your Honour will have gathered there was a fair amount said about, for example, what you should make of the Dubai execution judgment. I'm probably going to take it you know what my points are on that and what the points of disagreement are. So I'm not proposing to reiterate that in reply. I'm only going to try and pick off the points which I think were not new but not dealt with in my original submission. Starting at the end, if I can, this was the series of submissions made about the correspondence initially with DIFCA. So that was page 310 and 2094 during 2020, which you were brought to, and then the subsequent correspondence after that. The very short point, which I think Your Honour may have gathered from the request for execution that you looked at earlier, you'll remember there was the point 5 in that translated document, which said that the DIFC authority doesn't have procedures for the sale of the shares, and as such, the Dubai court is satisfied that it can, or the Dubai court should be satisfied that it can proceed in this way, and that's ultimately what leads to the 25th of July 2022 decision, which is the initial execution decision against the shares. And the point there is really to say that this 2020 correspondence with the DIFCA isn't really relevant to the questions in this case, because that was, in effect, the claimant generating the evidence it needed to put its application for execution before the Dubai courts over the shares. That's not something that we say is particularly relevant or that we rely on. And so whatever those documents do or don't say doesn't move the needle much. What my learned friend didn't really have an answer for in my respectful submission is what you do, Your Honour, when you get to these 2023 letters, which post-date the Dubai Court of Appeal execution judgment. And those in particular are the letters which are addressed to the Chief Justice of the DIFC, referring to the lifting of the attachment. And I think, as Your Honour has observed, the shorthand there, the use of attachment, is simply describing what the equivalent process is often described as onshore. When you get an attachment, it's like getting in what we would describe as being an injunction. And when the Dubai court writes to the Chief Justice of the DIFC, in the light of the execution judgment and also that decision I took Your Honour to earlier in July 2023 of the Court of Appeal, the Dubai Court of Appeal, what it's telling the DIFC court is clear. You should now lift these attachments, and it's difficult to see what else those letters could possibly mean. But if I can just refer Your Honour back to the document at page 1998. And I think that the point that my learned friend was trying to carve out was to say, well, you shouldn't read too much into this use of the word attachment, because an attachment is very different from a freezing order. And this isn't the Dubai court telling you to lift the freezing order, because it's a different thing. We say, first of all, it's clear what these letters are trying to convey. But in any event, we have this letter here, which states the Dubai Court of First Instance decided on the 15th of August 23 to address you, requesting the lifting of the freeze on the shares of the respondent in HMR Investment Holding Company, which holds the license. So again, what we say is it really couldn't be clear what the Dubai Court is trying to get across here. And it would leave open the question entirely. If that's not what the Dubai Court is trying to convey, then why on earth is it writing to the Chief Justice at all? So that's that point. Your Honour, I think, had also asked whether the DIFC court had responded to this. And I don't think that this document is in the bundle, because I didn't think it was necessarily going to move anything on. But as I understand it, there is a follow-up letter by the Dubai court on the 27th of November 2023, which is effectively a chaser to the Chief Justice saying we haven't heard back in response to this. And as my understanding of it is that the DIFC court hasn't yet responded to those letters. That's my understanding of the position. Going back, if I may, to a few of the points that were made at the beginning of Mr. Holloway's submissions, which I didn't address you on oral submissions earlier, but I'm happy to now. The first was this point about Article 7.1 of the Judicial Authority Law, and the suggestion that that might somehow be a gateway through which Your Honour has jurisdiction over this set of proceedings. Now, Your Honour, Article 7.1 of the Judicial Authority Law says, I don't know if Your Honour has it in front of you, I can take out the page reference if you need it, but you might be familiar with it.
Yes.
Does the execution judge assigned, pursuant to Article 5, shall have jurisdiction over execution of judgments, decisions and orders rendered by the capital C courts and the arbitral awards ratified by the capital C courts, if the subject matter of execution is situated in the DIFC, and such execution shall be in accordance with the rules of the court. All that Article 7.1 does is say that if you've got a DIFC court judgment, the DIFC court can enforce it. And the capital C courts is a defined term in the Judicial Authority Law, and it means the DIFC Court of First Instance and the DIFC Court of Appeal. What Article 7.1 doesn't let you do is to take the judgment of a different court, in this case the onshore Dubai court, and say that you've therefore got automatic jurisdiction to enforce under Article 7.1 there. That's not how it works at all. You can only really get to the point of Article 7.1 applying to either a Dubai court judgment or to a foreign judgment if you've already first gone through the relevant gateways, which are Articles 7.4 through to 7.6. So to give the example of how this works in respect of a foreign judgment, Article 7.6 means that if you are able to recognise the foreign judgment, you can then execute it in the DIFC in accordance with its procedures. And that then brings you to Article 7.1, which means that once you've recognised it and the foreign judgment is treated as a DIFC court judgment, you therefore have the jurisdiction to execute. That's not how it works when it comes to onshore Dubai judgments, because in order for you to get jurisdiction in the first place, you have to go through Article 7.4 and Article 7.5. And unless you do that, you don't have any jurisdiction of the DIFC court to go on and execute. It's as simple as that. So you have to go through the gateway first, and Article 7.1 can't have any application until that's happened. And my learned friend and the claimant aren't assisted by Article 7.1 because it's somewhat of a circular argument. Effectively, I think what you were being invited to accept is you made orders, an enforcement order back in February, which recognized the judgment and says, I can now enforce this as though it's a DIFC judgment. And because you've done that, even if you were mistaken in doing that because you didn't have jurisdiction to make that order in the first place, but the very fact that you've made the order means that you now have jurisdiction going forward under Article 7.1. But that doesn't work because you have to have had the primary jurisdiction, the prima facie jurisdiction to make that order in the first place. And the effective Sandra holding is, if we are correct, that the DIFC court exceeded its jurisdiction in making the enforcement order, the order has to fall away. And just to take you to a couple of points in the authorities on that, get the page referenced. The first point that my learned friend relied on this arose from the DMB case. Which is at 3139 is the relevant paragraph, I think was referred to, paragraph 116. And it's obviously relevant to point out at this stage that DMB were dealing with not the onward enforcement of a Dubai judgment, but of a foreign judgment. And what the court says is that you go through the jurisdictional gateway there, and what was Article 7.4 and is now Article 7.4 to 6. But 116 here says, I agree with the views of Justice Sir John Chadwick. As the phrase recognised foreign judgment is not found in the JAL, I will not adopt the use of this phrase to avoid confusion. In the present matter, it is clear that the judgment sought to be enforced as foreign money judgment, which is enforceable by this court. Once it is enforced, it becomes an independent local judgment of this court. So the point there is that in order for you to transplant this within jurisdiction and to treat it as though it is a DIFC court judgment, you first actually have to have the jurisdiction to enforce. And how do we know whether you've got that jurisdiction? Well, you have to look at Article 24 of the court law. Article 24 of the court law says your jurisdiction in respect of a Dubai judgment is conferred through Article 7.4, and that's what brings you within the Article 5A1E gateway. So you can't just skirt over Article 7.4. I think what my learned friend was Article 7.4 isn't about jurisdiction, but that can't be right, because if Article 7.4 doesn't say anything about jurisdiction, the question has to be, well, where on earth does the DIFC court's jurisdiction to enforce onshore judgments come from? Because it's not Article 7.1 and it's not Article 24 in isolation, because Article 24 is parasitic on Article 7.4. So we say that that argument doesn't hold. I'll skirt through the rest of the points briefly. There are a number of points, like I say, we would have made in response to what was said about the commercial companies law in relation to Article 22, in relation to the question of whether there's a distinction arising from personal status and so on. I can address Your Honour on those if you'd be assisted, but I don't know if Your Honour's view already is that you don't think you can be helped further on that by either me or by Mr. Holloway. If you feel you would be assisted by what I have to say about those cases, like I say, I'll go through those points. If not, I can move on.
No.
And the final point is just very briefly to and again, I'm not going to say anything lengthy about this because Your Honour has all of the points about Amwal, but just to counter the suggestion that there's only one piece of evidence, one which is Mr. Rashid's and unreliable versus Mr. Bestisto's, which is reliable. That's also not correct. I've taken you through the context, but what is evidence, which is relevant for Your Honour's purposes, is the multiple sets of translations that you have and what those say. And that thereafter it just becomes an argument between lawyers about the meaning of words, which I'm sure Your Honour is completely familiar with.
Lord, if that was his point, I had one very quick point that I forgot to make, which is not in any way responding to what he said any further, but if I could make it in 1 minute. But Mr. Dodd, I didn't mean to cut you off, but I thought...
No, that's quite all right. I'm just briefly checking with my instructing solicitors whether there's anything else they want me to cover. As I say, the rest of what I noted down all has to do with the Dubai execution judgment.
So I make my point quickly then. It's a 1 minute point, really. I forgot to mention the second decision of the Court of Appeal in Dubai, which is at 2100. That's the July 2023 decision to lift the attachment. It's a English 2108, I think. Lord, just 2108. That, if I could just sort of summarise that very, very quickly. What the court, the Dubai Court of Execution decided there was that because the shares could not be sold, there wasn't any point in that court continuing with an attachment, because if you can't execute against those shares, there's no point attaching them. Lord, that's the crux of that second Court of Appeal decision. Can you hear me, my lord? Sorry, I'm not sure if you can.
I can hear you. I'm looking at the judgment itself, which I'm not familiar with.
Right. There's a paragraph there that says, whereas the, no, sorry, yes, 2109, it's the final paragraph on that page.
Ron, if I'm not mistaken, I think this might be the judgment that I got you to earlier, which you read through, but maybe Mr. Holloway says I'm wrong about that.
This is the second Court of Appeal decision in July 2023.
Yes.
I just wanted to make one point on that, which I forgot to make, my lord, but the crux of that, which I think your lordship was asking, is that because these shares cannot be sold by the execution judge, there's no point in the execution judge continuing an attachment against them. That's the crux of it. And what I say about that is this: that is Dubai law. You attach and then you sell. That's part of the execution process. But it's completely different to our execution process, because the freezing order and the charging order, for example, even if you find, my lord, that you can't sell these shares, there is a very important reason why those orders should stay in place, because the judgment is still enforceable. And what should not be allowed to happen, and what the freezing order prevents happening and the charging order prevents happening, is Mr. Rashed selling the shares, pocketing the money, and not paying the judgment debt. So in Dubai procedure, you can see the sense in the judge saying, okay, I can't execute against these shares, there's no point me attaching them. But from our point of view, the freezing order, this is not the attachment process. It is basically saying there's a judgment which is enforceable. There's a very important reason why those shares should not be sold. A very important reason. To lift those orders, that's what can happen. And it's what will happen, I suggest, with impunity. So that was the point I wanted to make, and I'll leave it. Sorry, just forgot to make that point earlier.
Anything you want to say, Mr. Doherty?
No, Your Honour.
All right. Well, I shall reserve judgment, but you'll get it pretty quickly, and we'll see where we go from there. All right. Well, thank you both very much.